May I seek
My lord, if any complaint is there, they give
My lord,
to
this matter
place here.
was supposed to be listed
If
today.
you have any complaint against the officers, go to the RG office, make a complaint, it will come to not directly to the court open.
My lord, this matter was supposed to be
pleased to
listed.
fix the matter tomorrow at 12 noon.
Yes.
My lord was pleased to fix the matter tomorrow at 12 noon.
Ah.
But tomorrow is a holiday, my lord. The interim order is expiring. My lord can.
So why you are not mentioned yesterday?
My lord, I have
Yesterday all advocates are mentioned, given the mentioning list. Why you are not?
upon the.
Yes.
I have given a notice upon the respondent.
No, you are not mentioned the matter. Whatever the mentioned matter, you could have been mentioned the matter yesterday. So tomorrow, what can be done? It is not today in the list. So what can be done?
If a supplementary list can
Huh?
be a supplement subject to my lord's convenience. My lord was pleased to fix the matter 12 tomorrow at.
Correct. You could have been mentioned.
Then-
Supplementary method.
May it please your lordship, if I may have leave to mention one extremely urgent matter. It is running in your lordship's list today as item number 119. My lord, here the petitioner is an orphan. He had applied for a passport. It was rejected earlier. Again, he reapplied afresh, my lord. And now, for the time being, presently, he works in Tata Consultancy Services. He has been called to Finland by Tampere University for a conference from 13th to 17th September, my
Where
lord.
you have been called?
Finland, Tampere University. My lord, kindly hears the matter on a very urgent basis, my lord. If they are not issue my passport, I cannot get my visa. My lord, this is a golden opportunity for this
Item
petitioner.
number?
My lord, item number 119. If my lord is pleased to fix it on Thursday, I will immediately issue notice to the passport authority.
119. What is the name?
My lord, Moyuk Sarkar versus State of West Bengal and others.
Okay. Thursday. Thursday उसको रख दो within 5 minutes.
I'm grateful, my lord.
May I seek your lordship's leave, my lord?
Lordships, kindly, my lord, I was praying for leave, my lord, to move a very urgent petition. My lord, the petitioner is a clinical establishment. A request letter by the CMOH Purulia has, my lord, resulted in the total closure. My lord, no show cause has been served upon us as to why, my lord, it has been closed. But if your lordship, my lord,
When
kindly-
the notice was when the
8th
close.
of August, they have issued the notice.
Ah.
But 11th of August, they have shut down the clinical establishment, asked us to wait for 14 days. And that they would be issuing a show cause. 14 days has expired, no show cause. But if your lordship, my lord, hears it, my lord, the entire clinical establishment is closed. My lord, the police has been directed to shut it down.
So what is the allegation?
One allegation is
The show cause?
a patient was treated, she underwent a surgery. My lord, she took a discharge against medical advice, went to another clinical establishment, there she died. But not even in our clinical establishment. We have been shut down and nothing has been done as against it. If your lordship, my lord, kindly grants me leave, my lord, to move it because, my lord, there are, my lord, indoor patients, my lord, we are not able to treat them.
Where is the time?
But any day, my lord, could it be on Thursday, Friday, my lord, any day?
Not this week. 2nd September.
My lord, may I just seek leave, my lord?
2nd September.
This is
Issue
a request.
notice.
Short
notice I will not.
I'm seeking leave in a fresh matter, my lord. Your lordships have already heard a similar matter. As I'm a NEET UG candidate, I participated in the MCC counseling. I've been allotted a college, a deemed university college in Chennai. My seat is locked over there. Now the 31st is the last date for verification. For round 1 closes on 31st of August. Now, my lord, I'm falling under the OBC NCL category. I applied to the SDO office. The SDO received it. But your lordships will see a very precarious situation. The SDO called me and then returned my documents without passing any order. Because I'm only directing not issuance of the certificate itself, but I'm only seeking that my application may be adjudicated upon. Good or bad, it may be adjudicated upon. The last date is 31st, my lord. So lordships may kindly see.
My lord.
Issue notice.
Very well, my lord.
Issue notice Thursday, of course.
Thursday among the top 5 matters, my lord, if your lordships will permit.
Yes.
With the proceeding under the Senior Citizenship Act 2007, my deed was cancelled. Your lordship used to set aside the cancellation order. In spite of that, lordship, the deed they have cancelled. Lordship, I have filed a contempt application.
Who has cancelled?
Lordship, the concerned registrar. Your lordship set aside the order of cancellation order passed by the SDO in a senior citizenship proceeding. In spite of lordship, my deed has been cancelled.
So what you want?
Lordship, I have filed a contempt application.
File it. It will be listed.
Well, may I permit to
It will be listed. File it. Contempt application. What is urgent? It will be listed. Yes.
May I permit to mention, my lord?
Has not been listed. File it next week because my deed already has been cancelled.
My lord, may
What? This all the time. लेके रखो यार.
My lord, may I permit to mention, my lord, the petitioners are belong from the self-help group and they come to know the interested PM portion scheme.
Yes.
And the petitioners are belong from the self-help group and they come to know the interested PM portion scheme in Kolkata schools has awarded this scheme to the ISKCON and Annamrita Foundation, and the midday meal supply is commenced from 1st August, my lord. But the school didn't get any prescribed supply, my lord, for the midday meal. My lord, kindly include this matter, my lord.
What is the urgency?
My,
There's no urgency. Yes.
let the schools my lord, this is
By your lordship's code, this is item number 30
Hmm.
of the day's list.
Hmm.
Now, my lord, this is, my lord, your lordship is pleased to stay the blacklisting order. Now, despite that, my lord, we have been allowed to participate by the West Bengal government, but unfortunately, but Jharkhand, you know, I am stationed originally in Jharkhand, you know, citing the pendency, you know, they have not lifted this from the website, this blacklisting thing, you know, as a consequence, you know, the matter is in the list. I was only humbly beseeching your lordship, you know, certain tenders are coming up, you know, I am told, you know, next week. This matter was mentioned previously, the file could not be traced.
So what you want?
You know, I want, you know, if it can be taken up, if it can be taken up, day after tomorrow within, you know, I mean, or any day, you know,
Item number
30.
30. Please wait. Today, how soon? How far?
Otherwise, you know, let me disturb
Before
the-
rising the court, you mention if it is not taken up.
Lordship, may I be permitted to mention, my lord,
Today is
this
not the mentioning day. Why
The
every?
matter was listed, my lord, on Thursday and Friday.
Huh.
When I have checked the matter on yesterday, my lord, my matter was not listed before your lordship, my lord.
Which matter?
My lord, item number 149
Huh.
in Thursday's list, my lord.
Huh.
It was listed before your lordship, my lord.
Huh.
When I checked my matter on Monday, my lord, it was not listed before your lordship, my
Why
lord.
it is not listed? Why it is
My lord,
deleted?
149 on Thursday, 130.
Why it is deleted? I am asking you. Once it is in the list, so how it is going deleting? देखने का नहीं, हम जवाब मांग रहे हैं आपसे ना. डिलीट क्यों हो रहा है? चलो लिस्ट करो.
Grateful, your lordship. Grateful.
Yes, call the list.
May I have your lordship's kind?
Not such compelling circumstances. Yes, call the list.
May I have your
Call the
lordship's
list. Call the list.
And with the last order, my lord, the interim order was extended till today, my lord. It's expiring today, my lord. The pleadings have been completed. The matter is ready for also hearing, my lord. My submission is, my lord, kindly extend it for some times and kindly fix a date. We are ready with the hearing, my lord.
Who is for the other side?
I am for the Union of India, my lord.
Yes. What is the submission?
I am ready for hearing.
If my lord pleases, my lord can fix any day, my lord, for the hearing.
Matter is listed as to be mentioned for extension of interim order. It is submitted by the London Council for the parties. Pleadings have been completed and matter is ready for hearing. In view of the above, give the date October 12th October at 12 noon at 2 p.m. Interim order is extended till 14th October. 12th October? 14th October 2026 or until further order.
My lord, at 12 p.m.
12th
Next.
October.
12th October 2 p.m. Yes. Next.
But I am for the.
I'm for the clear.
This matter was mentioned by me.
Yes. Why? What is that necessary for
Correction, my lord.
what correction?
My lord, that mistakenly, my lord, recruited that copy of the witness supply. That was not my humble.
Lordship, kindly recalls.
One thing, my lord, subject to correction, my lordship. May I submit one thing? If my lordship permit me, my lord. This is the prima facie opinion of the court as I have understood it wrongly and not understood. Copy should be given. If it is the court's observation, my lord, don't treat as my consent. If the court feels, my lord,
What?
that copy should be given to the petitioner, my lord, is court's order may be passed, my lord.
So here,
As your lordship, my lord, as your lordship, my lord. As
what recorded? What is recorded? Counsel for the respondents press for time to file report disclosing the copy of the complaint in the witness.
copy of the witness not given, my lord.
The matter is listed as to be mentioned on the prayer made by the counsel for the respondent for correction in the order dated 21st of August 2026. This court finds that no correction is required. The order dated 21st August 2020 remain as it is. Remain unchanged.
But copy of the witness has not been
Next.
given.
For extension of interim order.
Yes. Which for the other side?
My lord, I appear for respondent number 2 to 5, my lord, Food Safety Authority.
Yes.
I appear for respondent number 2 to 5.
For filing affidavit for this file.
My lord, one kind indulgence, it is ready, my lord. It is pending with the department. The affidavit in opposition is ready.
How,
It's
how soon you file?
1 week. My lord,
1 week.
grants me 1 week's time to file the opposition.
I'll recall, there are some deficiency, that's why they rejected us. This deficiency has been now rectified and wrote to them. They may consider that also. And one difficulty with that, my lord, till date, in spite of my lord's order, they are saying that I have been debarred. What is called Facebook or what handle, Instagram handle, it is not known to me, I've learned and said.
একটা কপি দেবেন
It's affecting my goodwill.
Yes.
দেখে দে তুই
আমি দেখিয়ে দেবো হ্যাঁ লেখা আছে সুইটস
এইসব এত ফলোয়ার সবাই আমার রুমাল কিনছে না তোদের জন্য
না সুইটস কে
Yes, what is this? After the order of the court?
My lord, we shall take care of this.
Huh?
I was not aware of this fact.
Not aware, now you are aware. 30th July order was passed, first
My lord, my lord.
Then?
My lord, we shall take it down. My lord, may direct us to take it down, we'll take it down, my lord.
The matter is listed as to be mentioned for extension of interim order. Then counsel for the petitioner handed over the document and submit that in spite of the order passed by this, in spite of the interim order passed by this court, comma, the respondent authorities in the media published the item that published the Food Safety and Standard Authority of India has officially suspended the food business license of the petitioner. Land counsel for the petitioner submitted that he had no instruction, he will take instruction. Land counsel for the respondent for a week time to file affidavit in opposition. Let affidavit in opposition be filed within 1 week.
1 week's time.
1 week after serving the copy to the land counsel for the petitioner, counsel for the petitioner. Press what? 1 week, 2 week. 2 weeks to file affidavit in reply. Full stop. Let the matter appear on 21st September 2026 under the heading urgent motion. Full stop. The respondents are directed to act in accordance with the order passed by this court dated 30th July 2026.
Obliged.
Interim order is extended till the next date till 21st. 21st बोला है ना? Next.
Court, my lord, I am appearing for the state, my lord. My lord, pursuant to your lordship's last direction, my lord, 3rd July, my lord.
Why order?
A committee was constituted by the.
Look, this is the order.
This is the report, my lord.
3rd of July.
Yes, what is the report?
It is sealed envelope, my lord. My lord, may.
Catch it. साइड से काटो, साइड से उस साइड से काटो, इससे नहीं मिलेगा.
ওটা দিয়ে দিচ্ছি।
Yes. So the original record is not traceable anywhere. What are the record is there? They have already gave notified to the GP. GP. What is the stage of the case now? What is going on?
Trial, my lord, has not been commenced. Yesterday the matter was there, my lord, but due to the strike of the my lord, law matter could not be proceeded with. My lord, your lordship, my lord, your lordship's order, my lord, kindly takes, my lord, the order dated 3rd of July 2026. Paragraph 4, my lord, your lordship has said, my lord, that may I just place it, paragraph 4 of the order dated, my lord, 3rd of July 2026. In terms of the order passed by this court, the additional district judge had submitted an inquiry report dated June 19, 2026, wherein it was concluded that one SI Sri Rakesh Mishra is solely responsible for misplacement of the original case diary, GN number such and such, of the file of the learned Chief Judicial Magistrate at Barasat. So, I don't know, my lord, what is the report, my lord, whether, my lord, any step had been taken, my lord, against this particular gentleman, my lord, SI Rakesh Mishra or not. Kindly, my lord.
That is, they have only submitted the report with regard to their police jurisdiction. They have not with regard to the court complex. They have submitted that with regard to the police.
Yes.
2017 it was there. Thereafter it was weeded out, and with regard to the other subdivisional, the building was collapsed. Several documents have been, the records have been destroyed, so this might be
Might be destroyed.
and
If
that-
your lordship is satisfied, my lord, I am
Now,
nothing.
with regard to this, I don't know with regard to the
Other things,
district
Lord.
judge
Yes,
report.
Other
District judge
things,
report.
Lord, this is a serious issue, my lord. How these things happen, my lord. 3 CDs, my lord, went missing when a particular accused is a police officer. And it is going on, my lord, for the last from 2009.
Okay. So what you want now?
I want, my lord, to let the trial be expedited, my lord. Let the requisition be kept pending for the time being.
So what is the stage of the trial? What the
Trial, my lord, just PP has been changed. And my lord, yesterday the matter was there, my lord, matter could not be proceeded with due to the strike of
The
Lord.
39 pages, my lord.
and Vivas Chatterjee is
Yes,
there.
yes.
My lord.
So
Vivas
he is
Chatterjee engaged.
is conducting.
Yes. Well, some steps should be taken, not these errant officials. My lord. But these things, my lord, cannot be go, my lord, unpunished. My lord, this is a serious issue. If these things will not happen, my lord, that my lord, nobody will have touched the jury. My lord, your lordship will not kindly appreciate that fact also. I am languishing on since 2009 for justice, and these things happen as because a police officer is involved.
No, I find it is a common. Just I came not in the writ petition in my administrative side. I came to know in the Purba Midnipur the same thing has happened.
Absolutely, my lord, once
Same
the
thing has happened. CD
CD is
missed. CD missed, not producing. That
Lord,
in that
my
case the
lord, your lordship has the experience, my lord, in criminal jurisprudence, my lord, the initial pressure, if somebody, my lord, succumb to the initial pressure and obtains bail, then everything goes.
but the problem is that sitting in this chair and holding the post of the GP is some different.
Now, only one thing, my lord, in the last order, my lord, your lordship's order, my lord, paragraph 6, there is some typographical error, my lord, it should be corrected. Kindly see paragraph 6.
Yes.
Last 3 lines. It is stated, my lord, learned additional district judge 7th court. It should be 2nd court.
Second. ये डिस्ट्रिक्ट जज का रिपोर्ट कहाँ है? डिस्ट्रिक्ट जज का रिपोर्ट कहाँ है? सब कैसा कैसा कितना बार बोलता रिपोर्ट सबकी फाइल में बांध के रखो, सब उसी में टैग करके रख देते। यहाँ से सुनते यहाँ से निकाल देते, शाम होता सब भूल जाते आप लोग। डिस्ट्रिक्ट जज का रिपोर्ट आया था ना, कहाँ है वो? Record an order. In compliance of the order dated 3rd July 2026, 3rd July 2026, the Deputy Inspector General of Police Barasat Range had submitted the inquiry report, wherein it reveals that the committee constituted by the Additional Director General, by the competent authority in terms of the order passed by this court, the inquiry was conducted for tracing out the file, but it was found that the file could not be traced out. But from the Xerox copy of certain documents, a A duplicate CD has been created and has been handed over to the learned public prosecutor. Cool. Learned counsel appearing for the petitioner had drawn the attention of this court to the report filed by the district. No, sir, 7th court Barasat it is there.
Yes, it should be not a second court.
No, 7th court. The report is 7th court. It is mentioned.
Also, the second court.
The report submitted by the district judge, the additional district judge, 7th court.
7th court. The matter is pending with the second court.
But in 7th court, might be he was the charge. He bolche. Attention of the inquiry report submitted by the additional district judge 7th court Barasat, wherein after the inquiry, he has concluded that one SI Rakesh Mishra solely responsible for misplacement of the original case diary of GR case number 1842 of 2009 of the file of learned Chief Judicial Magistrate at Barasat. Accordingly, the department is directed to send this inquiry report to the Deputy Inspector General of Police Barasat Range for taking appropriate action against the said SI Rakesh Mishra in accordance with law. Full stop. As duplicate case diary has been constructed and submitted to the learned court as well as to the public prosecutor. Accordingly, which court? Learned trial court is directed. Learned trial court is directed to expedite the trial and to submit the report before this court on 14th of October 2026 by intimating the stage of the trial. The Deputy Inspector General of Police Barasat Range is also directed to submit report on the next date fixed with regard to the action taken against the SI Rakesh Mishra in terms of the inquiry report submitted by the additional district judge. Okay. This is the matter on 14th of October 2020.
Well, under the same heading, Lord.
Under the same heading. Under the heading order. For orders. Next.
मैं please your lordship
ना सारा रिपोर्ट एक में बांध के दो. पहले डिस्ट्रिक्ट जज का भी रिपोर्ट है, सबको एक फाइल में बांध दो.
May it please your lordship, my lord.
Yes.
Before your lordship opens the brief, could I in 2 minutes indicate in a nutshell, my lord? Then I will make it as short as possible. My lord, there was a fuel supply agreement which the petitioner had with Coal India.
What supply agreement?
Fuel supply agreement for coal, linkage coal. My lord, I had got that agreement. That was renewed and was valid till 2018. Was valid till 2018. But in the meantime, in 2016, my lord, some issue regarding theft was, my lord, alleged. On that ground, the agreement was terminated in 2016. My lord, we challenged that termination. My lord, before the Jharkhand High Court, termination set aside. Division bench, they preferred an appeal. Division bench said give them show cause and a hearing and all. After that, the order was passed again, upholding the termination. There was no order, and I shall show from the records, no order of blacklisting or debarment. But I am not even inviting your lordship to decide the issue of blacklisting. But even if it is taken to be correct, I have served my sentence twice over. Their rules, I shall show, gives me 5 years maximum blacklist debarment period. Even if I am held guilty, I am convicted of any offense, anything of that sort. 2016 termination, 5 years is 21. Now we are in 2026, 5 more years. So after having completed the sentence, my lord, I cannot be debarred. Now, my lord, there was an order which they say, there is a communication, they say that you have been debarred in 2021. Even if I take it to be correct, that 5 years from that period is also over.
So, my lord, whichever way, my lord, I am not even calling upon your lordship to decide on the niceties of blacklist. Even if it is correct, I am still, my lord, serve the sentence. Having served the sentence, they cannot, my lord, stop me from participating in the tender. Your lordship would kindly have a look at the interim order in the writ petition and why, my lord, we have been constrained to file this can, my lord. Your lordship would kindly have a look at page 55 of the application once, my lord. This is the subsisting interim order permitting us to participate. But may I place? It's a very short order, my lord. I'll just place. The learned counsel for the petitioners has raised an issue as to whether there was ever any order of debarment of the petitioners from participating in the respondents' tender. Even if such an order was there, in view of lapse of more than 5 years, which is the outer limit for such ban, it is submitted that the petitioners should be permitted to participate in the tenders floated by the respondents. Learned counsel for the respondents was to take instructions as to whether any order of debarment was specifically passed against the petitioners. When the matter is called on today, learned counsel for the respondents places reliance on annexure P12 at page 101 of the writ petition, which is a communication dated such and such issued by Central Coalfields to the petitioners and submits that the said communication is the first order of banning. However, the said communication does not disclose any order of debarment of the petitioners. Thus, since the respondents have failed to produce any document to show even prima facie that the petitioners were ever debarred from participating in the respondents' tenders, the petitioners are allowed to participate in all tenders floated by the respondents subject to eligibility otherwise. Accordingly, the respondents shall remain restrained from preventing the petitioners from participating in the tenders floated by the respondents during pendency of the writ petition, subject, of course, to the eligibility otherwise of the petitioners to participate in the tender. Up till here, no problem. Problem is one of the next paragraph. It is made clear that any action taken pursuant to such ad hoc order will be subject to the ultimate result of the writ petition. Now, my lord, we have written letters to them.
So what? This is a writ petition.
This is the can, my lord. This is the
writ petition means the
main writ petition.
This is a writ petition.
Yes.
May I be allowed to file my affidavit in opposition to the main writ petition, my lord?
Now, my lord, why this application is necessitated? My lord, there have been subsequent tenders where, my lord, officially there is no debarment. Even if I take there is a debarment of 2021, my lord, let us not go into any.
What has happened?
Now, my lord, there are new tenders coming up. Officially, they have communicated to us that yes, kindly see page 63 of the can. They say that yes, you can participate. But, my lord, we have, my lord, come to learn, my lord, from reasonable sources that, my lord, this is really an eyewash. It's a facade. Why we have to come running to your lordship despite that order? Kindly seize this stand. After that, they really cannot, my lord. It is clarified, may I place it? It is clarified the CCL-CIL has not issued any specific order debarring or blacklisting your company from participating in tenders or auctions. However, the fuel supply agreement that is such and such executed with your company was terminated in accordance with the provisions of the said agreement, consequent upon action taken under the relevant contractual provisions. The Honorable High Court at Calcutta video interim order dated such and such has observed that no specific order of debarment had been produced before the court and has directed the petitioners shall not be prevented from participating in the tenders floated by the respondents subject to their fulfillment of the applicable eligibility conditions. The Honorable Court has further clarified that the said arrangement is subject to final outcome of the writ petition. Accordingly, CCL has no objection to your company submitting its bid in NRS linkage auction tranches conducted by Coal India Limited. However, participation, consideration of bids, and execution of any fuel supply agreement is, if otherwise applicable, shall be governed strictly by the eligibility terms and conditions and prescribed in the relevant scheme documents, including any provisions relating to eligibility, ineligibility, and shall also remain subject to any orders passed by the competent court. But they are citing pendency of the writ petition, where we have prayed for a declaration. So, my lord, even if we participate, my lord, there is a clause that if there is any pending proceeding, so, my lord.
No, they have. Can you see the paragraph 3?
Exactly, my lord. On paper, my lord, I do not have a cause of action. Absolutely, your lordship is absolutely correct.
Correct. So then,
but that this is, my lord, my information from relevant source. Why we had to come running to the court? That, my lord, even if we participate, citing the pendency of the writ petition.
If they cite, they have to face the consequences.
But I am only praying for one small order, my lord. This pursuant to this communication of this, the writ petition may be disposed of because this is the stand taken. They have not disclosed any new document with the affidavit in opposition. We have not used any reply.
No, but with regard to the termination of the agreement.
I am not challenging. I have served the sentence of 5 years plus 5 years. I am not raising any question, my lord. So, my lord, this writ petition may be disposed of in light of the stand of this, so that they cannot cite pendency of the writ petition and say that, oh, okay, you can participate, but your bids will not be considered.
Yes. Who is, you are appearing?
Yes, I am for the honors.
My lord, before going to the merits of the allegations, my lord, may I take your lordships to the prayer, my lord, made in the CAN application? And kindly comes to page 13.
Yes.
Now kindly see the prayer C. An order be passed directing and or clarifying that petitioners are entitled to participate in upcoming NRS linkage auction during the pendency of the petition, writ petition. Subject to correction by your lordship or by my learned friend. But on any application nature of a clarification, and can only come to the regular bench if the honorable judge passing the original order is not available in this court. So, my lord, I am asking myself, and I am leaving it to your lordship as to whether this application can be entertained at this stage by your lordship, sitting in the regular determination.
An order passing, directing, clarifying the petitioner entitled to participate. That's why, see, if it is required clarification, this court can't.
Yes.
But that's why I'm asking Mr. Gupta, because the court has already clarified you are allowed to participate. So where is the cause?
Kindly ignores my application. Kindly takes the look at their annexure at page 63. Kindly disposes of the writ petition in that line, my lord. I have nothing remaining, my lord. I have served twice the sentence. I cannot.
When the order was passed.
30th of November 2023.
May I request one thing? Live stream can be paused for a moment. Live stream can be paused for a moment.
Yeah, live.
10.
And where is the clause of criminal case?
No, it kindly comes to page
Page 123 of the can. 133 of the can, my lord.
194 of the writ petition as well, my lord.
194.
Yes.
The present one is in the can, my lord, if your lordship kindly. The present link, that clause is in the can.
Page.
At 133, my lord, of the can, my lord. Volume 2. Volume 2 of the can, my lord, page 133.
Yes. Where is the clause?
My lord, kindly sees clause FF at 135. Clause F. Treatment of cases against which misutilization of coal was reported earlier and action already taken by the coal companies. The above provisions will also apply to all units uniformly, including those suspended earlier, and based on certain reference findings of coal company in case the stipulated period of suspension banning as it may has already exceeded 5 years. The status of such units shall stand restored automatically. I am on this.
No, that is
in line with the aforesaid.
My lord, kindly
that
comes
is
to
correct
page,
with regard to the criminal matter.
my lord, 133, my lord, clause 2, subclause 2B.
133.
Yes.
133.
They are relying on B. I shall show, my lord.
C, my lord, C. This is not C.
If a charge sheet is filed within 6 months of the suspension, the suspension of supply of transaction will continue. Where is the bar?
My lord, then E.
In case the unit director found guilty and convicted.
But sorry, my lord, I am very sorry, my lord. Kindly comes to A, my lord. One, receipt of communication from statutory authorities.
No, that's
The consumer put under suspension will be eligible to participate in interest linkage auction till charge sheet is filed. However, in case charge sheet is filed, the
Where
unit,
from you are reading?
my lord, clause A, my lord.
My lord,
Above,
at
my
the
lord.
top. At
At
the
the
top, my lord. Page 133, capital A.
Yes, major communication from the statutory like CBI, police,
No, no,
court,
it-
etc. containing allegation finding.
My lord, kindly come to my lord, B clause Roman 2A. B Roman 2A, participation under interest linkage auction, there is one highlighted.
Yes.
On receipt of communication from statutory authority, the consumer put under suspension will be eligible to participate in the interest linkage auction till charge sheet is filed. However, in case charge sheet is filed, the unit will not be eligible to participate in any auction or to sign FSN till his acquittal clearance.
So you are not challenge this clause.
No, I do not need to, because your lordship would kindly come to B, the clauses above that, E. In case, no,
In case charge sheet
In
is filed,
case-
suspension will be reimposed and supply of coal will not
that is
will
B.
only
Kindly
be
sees
restored.
E. Kindly sees E. Is found guilty, convicted, suspension will continue for a period of 5 years, effective from the date of commencement of the last
That is
suspension.
conviction, convicted.
Whichever is earlier.
Guilty, suspension, and for a period of 5 years.
So,
effective from the
commencement of the last suspension or completion of penalty, whichever is earlier. Penalty is, my lord, the clause above that, 5 years. For a period of 5 years. So, my lord, whichever way your lordship looks at it, it is 5 years. And 2, Roman 1C, my lord.
If the charge sheet is filed within 6 months from the suspension, supply will continue.
My lord, 2, small Roman 1 at page 134.
That's a contradictory. D is contradictory then.
No, my lord.
In case charge sheet is filed, suspension will be reimposed and supply of coal will only be restored as per the terms of FSA only on acquittal and clearance.
Yes, but kindly sees 2 after that.
So if you read D, 1D,
Yes, my lord.
and if you read 2A, that is a contradictory.
If found guilty, convicted, banning for participation will continue for a period of 5 years, effective from the date of commencement of the last suspension. My suspension is 2016. Even if I take it as 2021. So 5 years from that. Or date of conviction, whichever is earlier, not later. So conviction may be in 2030. But if I have already served a sentence of 5 years, whichever is earlier.
That's why I'm telling. Then read 2A.
Yes, kindly
Read
see the
2A.
clause after that, my lord.
Read 2A.
To
IIA.
IIA. On receipt of communication from statutory authority, the consumer put under suspension will be eligible to participate in the NRS linkage auction till charge sheet is filed. However, in case charge sheet is filed, the unit will not be eligible to participate auction till his acquittal or clearance. So that is qualified. by this that it may take 20 years for a.
That's what I'm telling.
So kindly also see, my lord, English 2 after that, my lord, the clause D after that. Misutilization of coal as per findings of the company, that is the heading, page 134.
If found guilty,
Yes.
convicted, banning the partisan will continue to corrupt.
No, my lord, yes. After that, my lord, English 2, misutilization of coal as per findings of the coal company.
Correct.
Kindly see C. In case of misutilization of coal under the present or past FSA is proved at any point of time, supplies of the unit will be suspended for 5 years. In such case, all running such and such will be terminated as per the provisions such and such into and were entered into consequence of MDA. So, my lord, this had already taken place in 2016. So, termination 2016, suspension is from 2016. Even if I take their banning order from 2020, 2016 is my termination, original termination.
Where is that? No.
Yes, my lord, that your lordship would find.
That is 2021.
No, that the original termination is.
Original time then set aside.
Then set aside. So
it has come there subsequently as
yes.
per the
2020.
order.
Very well, your lordship will take 2021.
Correct. 2021.
2021, that is 29 June. Still 5 years
29
gone.
June 20.
5 years gone.
5 years is completed.
So if 2016 FIR is lodged and they do not take any steps, so for indefinite period, this is what the judgment is, Aroma Coke, which says no entity can be banned for an indefinite period.
That's correct. That's correct.
And interpreting this clause.
Pendency of the crime. What is the case? 380?
No, it's case of a theft.
That's why 380, 379.
Oh, I do not.
There was 420, 406, since allegation pertains to misutilization of coal. Misutilization of coal. And that to a very large scale.
468.
468 was also there. Yes.
Change of the.
Doctrine of proportionality, reasonableness, everything is going for a toss.
The 420 case, definitely, because the purpose for which coal was auctioned for, that was not utilized.
Kindly sees the.
Otherwise, coal would not have been allocated. He was not even eligible to be.
2016, I'm out of business.
The petitioner has filed the present application being Can 1 of 2026, praying for an order directing the respondents to implement the order dated 30th November 2023, or by clarifying that the petitioners are entitled to participate in the upcoming NRS linkage auction during the pendency of the writ petition.
Could I take a lordship's leave?
Great petition. Full stop. And counsel for the petitioner submit that initially the petitioner was suspended in the year 2016. Subsequently, the 2016, the said order of suspension was challenged by the petitioner before the Honorable High Court at Jharkhand.
My lord, if I may hand over the affidavit of service.
Honorable High Court at Jharkhand. Full stop. The Honorable Single Judge of the Jharkhand High Court has set aside the suspension. Subsequently, the respondents Coal India Limited has filed an appeal before the Division Bench of Jharkhand High Court, and the Honorable Division Bench has given liberty to the authorities for if the authorities intending to proceed against the petitioner, the so-called notice be issued, and after opportunity of hearing to the petitioner to pass appropriate order. After the order of the Honorable Division Bench of the Jharkhand High Court, the respondents have passed the impugned order dated 29 June 2021, which is impugned in the present date application. Counsel for the petition submit that if we go by the suspension of go by the impugned order dated 29th of June 2021, the petitioner's suspension is over for a period of 5 years, and as such that same cannot be continued more than the 5 years. The petitioner has relied upon the interim order passed by the coordinator of this court, in the present date application dated 30th November 2023, wherein this court has restrained the respondents by preventing the petitioner from participating in the tender floated by the respondent during the pendency of the writ petition, subject, of course, the eligibility otherwise of the petitioner to participate in such tender. In the said order, this court has further clarified that any action taken pursuant to such ad hoc order will be subject to the ultimate result of the present date application. Learned counsel for the petitioner submit that as the petitioner has completed the suspension period of 5 years and nothing remains in the present date application. The petitioner has drawn the attention of this court to the communication dated 15th of July 2026 issued by the CCL, wherein it was informed to the petitioner that inward comma CCL has no objection that the petitioner company submits bill in NRS linkage e-auction tranches conducted by the Coal India Limited, full stop, however, participation, consideration of the bid and execution of any fuel supply agreement, if otherwise applicable, shall be governed by strictly by the eligibility criteria, terms and conditions prescribed in the relevant scheme documents, including any provisions relating to eligibility/ineligibility, and shall also remain subject to any orders passed by the competent court or other competent authority from time to time. Full stop. Then counsel for the petitioner has brought the attention of this court to the has relied upon the judgment in the case of Aroma Coke Limited and another versus Coal India Limited and others, reported in 2023 SCC Online Calcutta 2110 and submits that this court by relying upon the ratio laid down by the Honorable Supreme Court held that the petitioner cannot wait indefinitely for participation in any tender floated by the CIL or its subsidiaries, which operates adversely against the goodwill and the business of the petitioner. By referring this judgment, the land counsel for the petitioner submits that in the present case, though the suspension period of 5 years is completed, but the criminal case is pending, and due to the pendency of the criminal case, the petitioner is apprehending that the respondent authorities will not consider the bid of the petitioner if the petitioner participate in the said bid. Full stop. At the land counsel appearing for the respondent authorities initially raised the question of maintainability of the present application being can of 2023 by 2026 by referring clause prayer C of the said application and submit that if the petitioner intending that the order passed by the coordinate bench dated passed by the honorable judge dated 30th/11/2023 is to be modified or clarified, the petitioner has to move the present application before the honorable judge who is presently available before this High Court. He further relied upon, he has drawn the attention of this court to the tender conditions and submit that as per the said tender condition, it is categorically mentioned that it is mentioned that on receipt of communication from the statutory authority, consumer put under suspension will be eligible to participate in the NRS linkage auction till charge sheet is filed. Full stop. However, in case the charge sheet is filed, the unit will not be eligible to participate in any auction or to sign the FSA till his acquittal of the clearance. By referring the said clause, the land counsel for the respondent submits that though the petitioner has completed the suspension period of 5 years from 19 June 2021, but the police has completed the investigation, submitted the charge sheet, and the case is pending against the petitioner before the competent court for adjudication. He further submits that as per the set terms and conditions, if the petitioner is not acquitted from the criminal case, it is the respondents will not be in a position to consider the bid, if any, submitted by the petitioner. Heard the learned counsel for the respective parties, peruse the materials on record and the judgment relied by the petitioner. There is no dispute, there is no quarrel with regard to that the order dated 29 June 2026. There is no quarrel that by an order dated 21st of 29th or 21st 29 June 2026 2021 comma the petitioner is declared ineligible to participate in the NRS linkage auction T-4 others cooking subsector in terms of clause 4 within bracket A within bracket III of the scheme of the documents dated 30th May 2019. Full stop. This said impugn order was passed on 29th of June 2021. The period of 5 years has been completed, and as such the force of the said order has lost its force. Now the authorities cannot take the benefit of them, take the benefit of the said order by restraining the petitioner for participating in the said tender. Now the only question that during the pendency of the criminal case, whether the petitioner can participate in the tender or the respondents can reject the tender only on the basis of the pendency of the criminal case. Full stop. In Annexure 6 clause B within bracket I, clause 6 Annexure 4 clause B of the tender documents reads as follows. Eta kori hai. ठीक है ना, लेके यहाँ तक का कर दे. Clause II within bracket A debar the petitioner to participate in the said tender pendency of the criminal case unless the petitioner is not acquitted. But clause 1I, which will be at the base, which one? IE, small e, provides that in case a unit or its director is found guilty of the convicted, suspension will be continued for a period of 5 years, effective from the date of commencement of the last suspension or the completion of penalty, whichever is earlier. The clause D provides that in case charge sheet is filed, suspension will be reimposed and supply of coal will only be restored as per the terms of FSA only on acquittal, clearance on an order of the effect by the investigating agency or the court. This court finds that the incident was occurred in the year 2016. And 2016 itself, the criminal case has been initiated. After initiation of the FIR, investigation has been completed, charge sheet has been filed, and still the criminal case is pending before the court. In the case of Aroma Coke Limited and others, the coordinate bench of this court held that, page paragraph 36. Okay. In the present case also, as per the clause of the tender, the petitioner will not be in a position to participate in this tender process due to pendency of the case. But this court relying upon the judgment of the Supreme Court has categorically held that the petitioner cannot wait indefinitely for disposal of the criminal case, being restrained in the meantime from participation in any tender floated by the CIL or its subsidiary, which operate adversely against the goodwill and the business of the petitioner. Full stop. Considering the above, this court finds that since the year 2016, till date, the petitioner has not been allowed to participate in the tender process as the petitioner was placed under suspension. suspension. Now only the criminal case is pending. It is not neither the state nor the petitioner had any knowledge when the criminal case will be concluded. Accordingly, considering the above aspect, this court find that for the last 6 years, for the last 10 years, since 2016, you are not participating.
No, Your Lordship.
Since the last 10 years, the petitioner is not participating in the said tender process, and the final order of suspension was passed on 29th of September 2021. The 5 years period is also over. Accordingly, the respondents are restrained. And accordingly, repetition is disposed of by allowing by directing the respondents to allow the petitioner to participate in the future tenders subject to fulfillment of criteria, but not to reject the participation of the petitioner in the said tender on the basis of the criminal case pending against them. Writ petition is
on the ground of pendency of the criminal case.
Grateful, Your Lordship.
Grateful. I'm sorry, my lord.
This was can as well as the
But opposition filed on behalf
of the opposition. Next.
That appear for the petitioners, but not lordships.
But I appear for the private respondent, respondent number 12.
Yes.
Only volume 1 and 11. I take to 1 and 11. Clear.
1 and?
Volume 1 and 11. Not
But before my learned friend,
And I'm appearing for the state respondents, my lord. I'm led by the learned advocate general. I have been instructed to seek an accommodation for today because the instructions we have just received outside the courtroom, my lord. The learned AG is on his legs, my lord, in courtroom 4. I have been instructed to seek an accommodation for today. Kindly, before my learned
When?
can start, my lord.
Sir.
Then not today,
Then not today.
Not today. What is the urgency, Mr. Majumdar?
It's no,
Tender.
before, that cannot be, before that, kindly see the size of the brief.
That's an
Lord,
That's the best point. If they can carry it, Mr. Mojumdar can carry it, he pass the entry order. What is asking for? Very well. Please indicate the distance.
From end to chamber.
That's all. But 1st September is the date from which the contract will take effect.
Then
But we can come back.
Come on 27. Not today.
I'm grateful.
But same position. Not
Same position, huh? At the top.
কোথায় এটা তুলে ফেলে দেন
Yes, next.
Lord, I'm appearing for Union of India.
My lord, this is a petition before your lordship, my lord.
Yes.
Petitioner is suffering from, my lord, various ailments, my lord. I have a blockage in my heart, my lord. I have a diabetic patient. There's a visionary problem, my lord. Initially, my lord, I was given the duty of discharging the enumerator, my lord. At the very threshold, my lord, if your lordship kindly come to my lord, page 26 once, my lord.
Where is your order for appointment?
My lord, order was given 14th of my lord, August, my lord. My lord, when my lord I was called for my lord by imparting training, my lord. At that very threshold, my lord, I written to them. I am a diabetic and cardiac.
Completed the training.
I have completed the training, my lord. Thereafter, my lord, pursuant to as a loyal employee, my lord, I was conducting the work, my lord, for the last 2 weeks, my lord. My lord, I am facing severe problems, my lord, which I have categorically stated in para number 16, 17, and 18, my lord. That, my lord, first problem is, my lord, that I have to travel a lot.
Where is a medical document?
My lord, medical documents, if your lordship kindly takes, my lord, the 32 once, my lord. Page 32, from 32, my lord, it starts. And my lord,
Heart patient Sankar Netralaya.
Yes, my lord. And my lord, page 40, my lord, the vital document, my lord.
32.
No, my lord, page 40.
40.
Page 40. Yes, my lord. Your lordship kindly sees, my lord, impression. As your lordship got it?
42.
42, my lord.
Yes.
Impression, my lord, sinus rhythm with complete right bundle branch blockage, my lord.
Where from you read?
My lord, the bold written, my lord, after the column, my lord.
block. Impression, my lord. Has your lordship? Impression, my lord. Sinus rhythm with complete right bundle branch block, my lord.
Cavity size normal. LV non-regional, no regional wall motion abnormality. Good. Diastolic compliance reduced. Normal size. Yes. What is the what is the no?
No, my lord.
Not normal.
Not normal, my lord.
What no not normal?
My lord, there is a blockage, my lord. You will also kindly see the impression, my lord. Sinus rhythm with complete right bundle branch block.
Where from you are reading?
My lord,
page 42.
Page 42, my lord. The bold one.
42.
40, my lord. Oh, sorry. Page. Sorry, my lord. Page 40, 40, my lord. Impression. Your lordship has got it, my lord. Impression, my lord. The last bold one. Sinus rhythm with complete right bundle branch block, my lord. My lord, I am having a, my lord, blockage, my lord, in right side, my lord. So, my lord, there is a, my lord, for that reason, my lord, I am facing difficulties, my lord, and I am a diabetic, my lord. My lord, there is a problem of urination, my lord. Whenever, my lord, I am visiting, my lord, within few intervals, my lord, I have to urinate, my lord, but there are no public toilets also, my lord. These are the problems which you are facing, my lord. For that reason, my lord, I am compelled to come before your lordship, my lord. I have entire medical history, my lord. Apart from that, my lord, yesterday I spoke to my client. When, my lord, I was given a duty of, my lord, presiding officer in last election in 2024. When I was discharging my duty, my lord, I suddenly fell ill, my lord, and I was to admitted in hospital, my lord. Even I have those documents. I was.
That is not annexed.
No, my lord, this was not annexed because when I spoke to my client with regard to, my lord, the problems which he is facing, my lord, he has yesterday, my lord, at night he told me these are the documents, my lord, which while I was discharging my duty as a presiding my lord, presiding officer, my lord, I was hospitalized, my lord. So, my lord, I only beseech your lordship, my lord, there is a genuine problem, my lord, and there is a specific averment to that effect that if they want, my lord, I can undergo a medical test also, my lord. In paragraph 12, my lord, specifically stated, and in my prayer also, my lord, prayer D. It is, my lord, in paragraph 12, my lord. Your petitioner states that if the respondent authorities have doubt with regard to the elements of the petitioner, then they can conduct a test upon your petitioner, my lord. I am ready and willing, my lord. Because I have the documents.
By that time, the census will be over.
Only I have, your lordship kindly appreciate. Being a loyal employee, madam, they have directed me, I have discharged my duty. It is not that
you tell me you are appearing in your duty.
Yes.
You are getting your
yes, I spoke to my lord. Yes, my lord. I spoke to my lord. While I was discharging my duty as a teacher, I had to sit in the classroom, my lord. I was imparting education to the pupils, my lord. No physical exercise, my lord, is being performed by me. But, my lord,
but the teacher no physical.
No, my lord. I have to, my lord, to and fro from my house to the school, my
more
lord.
difficult.
No, my lord. I have to speak, my lord. I have to speak, my lord. But here, my lord, there is a physical exercise, my lord.
Digitally, my lord. Here,
No, my lord. The person is here, my lord. If your lordship wants, my lord, for that reason, and I have made a specific prayer also, my lord. Prayer D. If they have any doubt, my lord, they can, my lord, call me for a medical test also, my lord. Only, my lord, for that reason, I am before your lordship, my lord. Only for the medical reasons, my lord.
Yes.
Though the state is the one main answering authority, we are appearing for the Union of India. But on behalf of the Union of India, submit, my lord, he has undergone the training. He has not initially, when he appointed, he did not raise any objection. Subsequently, he has made out this case, my lord, for this. He has made a representation, my lord. This court is not. What is the degree of the disease? That cannot
yes,
be.
What is the state?
Today I have received the instructions. I have not.
What sometime that's why when your the census is going to be over. So why you're not considering? Why you're not allowing or rejecting? Why you're not taking the decision? If these are the serious nature of the work which has been assigned to the petition and making the petition made the representation to you. Why you're not considering all this? Why you're keeping in file? Who is the authority to decide this? Census is awarded. Who will decide whether she is suffering for the ailment or the cardio? She is suffering from the cardio. Huh?
Charge officer.
Charge officer. Charge officer BDO. Where is the order? Who has given the order?
Well, order is that if you look at the first annex, my lord, at page, my lord, page 22, my lord. Charge officer, ward number 90 has issued me, my lord, the appointment letter.
Charge officer, who is he?
My lord, I have
Designation.
What is the designation?
Where
is the representation?
My lord, page 27, my lord, is my representation. 26.
That is also by email.
Yes, my lord, along with all the documents I have
Where
enclosed.
is the representation?
Page 26, my lord.
26. 26, the sent by mail. Where you have not given the?
No, my lord, I have not given, my lord. I have sent it through mail because your lordship kindly.
You could see in the mail you have typed the word, then you couldn't print and file before the what is your given in the representation. How the court can consider? Representation.
This is the mail representation.
Where is the attachment?
My lord, the attachment of the medical documents, my lord, which I have enclosed, my lord.
So where is the request? This is only request. Census duty, I am suffering from cardiac diabetes and long periods, so I am humbly requested to release me for. That's all. Rightly rejected.
They are not taking a decision, my lord. Till date, my lord. I was, my lord, performing my duty.
This is the way. Sending in the house and you give the representation through online 2 lines application, 2 lines application, and you're thinking that the authority will consider.
My lord, I was under the impression, my lord, I can conduct the work, but after conducting the work for 2 weeks, my lord, I am facing problems.
What work you are doing? Which class teacher?
My lord, a high school teacher. I am teaching history, my lord.
Which class? In which class?
Secondary or primary? Higher secondary, my lord.
History, higher secondary. So history.
I'm sure, sir.
So history is connected with the census.
I have some mercy upon me.
You're the best person to go for the census duty.
My lord, I would, my lord, but the problem is my health is not permitting.
Which area you're residing?
My lord, I reside in Konnagar in Hooghly, my lord.
Hooghly. And which school you have posted?
My lord, I am posted in Jodhpur Park in.
Where is a good hospital? The hospital, SSKM? Or which hospital? I am sending you to the medical board.
My lord. SSKM.
I am sending it to the medical board. When the medical board is tomorrow? Let's see appear before the medical board. If she found that yes, she is suffering from, then pass appropriate order. Otherwise, his salary will be held up for the 1 month and that may be sent to the legal aid society.
I'm asking. No, my lord, I spoke to my client, my lord. He is ready, my lord. This is my specific prayer, my lord. I can undergo a medical test.
Well, he can come to High Court from Konnagar.
Lordship, this is a source of my bread and butter, my lord. I have to, my lord. If they give a work, my lord, well, I can discharge my duty by sitting, my lord. I am ready, I am willing, my lord, to do that, my lord. But here, my lord, there is a physical exertion is required, my lord.
Which hospital?
SSKM is the best. Your lordship direct the authority to consider, my lord.
No, my lord, medical board, your lordship, my lord, kindly, because I spoke to him, my lord.
But his representation is not.
That is the.
My lord, your lordship, my
I
lord.
wanted to see the representation. You have not stated anything.
My lord, may I beseech your lordship, my lord, late my writ petition, my lord, I will bring, my lord, I will take all the medical documents along with me, my lord. They will conduct a test upon me, my lord.
You make a fresh representation.
The petitioner has filed the present writ application with the grievance that the petitioner has been assigned the census duty, but the petitioner is suffering from heart ailment and is also under treatment. And as such, the petitioner has made a request to the authority along with the medical documents with the request to release her from her duty from the census duty of 2027, but the authorities will not consider the representation of the petitioner. This could find that the petitioner has submitted the representation to whom you have submitted the representation?
My lord, the census officer, my lord, the respondent number 12.
To the charge officer?
Yes, my lord.
To the charge officer. Respondent number 12. To the respondent number 12, the charge officer, ward 090 KMC census 2027. But the same has not yet been considered. Accordingly, the repetition is disposed of by directing the charge officer to consider the representation submitted by the petitioner through mail dated 27th of July 2026.
My lord, only one thing, my lord. I took instruction, my lord. I had went, my lord, to deposit the hard copy and I refused. I had sent the mail, my lord, to the same
27th July 2026. 2026, and at the time of considering the request of the petitioner, if the respondent number 12 finds that the petitioner is to be sent to the medical board to ascertain with regard to whether she is suffering from any ailment, comma the respondent number 12 can send it to the medical board or obtaining report. If the respondent number 12 request the health authorities for constitution of the board for examining the petitioner for her illness, comma, immediately the authorities shall constitute the board for examination of the witness to ascertain whether the petitioner is actually suffering from the ailment which the petitioner has relied upon her representation, and to submit the report to the charge officer, and getting the medical report, if any, constituted by a medical report of the medical board, if any constituted, comma, the charge officers decide the same as early as possible, preferably within a week from the date of receipt of this order.
Communicate. My lord, I'll serve a copy to them, my lord. To respondent number 12, my lord.
Yes.
And only one thing, my
That
lord,
is
because
there. You serve the copy, and they will.
no, only one thing, my lord. I'll download the server copy, my lord, serve it to respondent number 12, my lord. And board will consider and they will furnish a report to your lordship.
You go and they will examine you.
My lord. And your lordship has made the matter returnable, my lord.
Dispose of, I dispose.
Grateful to your lordship, my lord.
Wait, I appear for the petition. Wait.
Look, the impugned letter is at page 271. Second volume.
271.
Yes. Huh? No, it's copy of the petition. Stated No, have you served? Have you served?
We have served. It has been sent. I don't know. He's for the union.
You are appearing for whom?
Union.
Others have got it.
Who is appearing for the? Who is the main respondent?
Railways.
Railways. You are appearing. Railways also.
I will call 1, 7, and 8.
1, 7, and 8. Actually, the letter which is impugned is the letter issued by RDSO, I think.
RDSO. So you are appearing for the RDSO. 1, 7?
7 and 8, your lordship.
1, 7, and 8. RDSO, he is appearing.
1, 7, and 8. Yes.
Yeah, praying, just we got this restriction. 2 weeks time to file affidavit.
2 weeks.
My lord, we have to go all the documents which has been annexed.
Lord, I tell your lordship, Lord, in short, what the challenge is, if your lordship comes to page 271, I'll just, to indicate my learned friend, Lord, it's not a very heavy writ petition. Your lordships kindly come to page 271. Kindly, Lord, take paragraph 2 and paragraph 3. In view of the above, they are relying upon certain test reports, etc. It is concluded that the firm has failed to maintain the quality of its product. Accordingly, under clause 4.2 ISO documents, etc., the competent authority has decided to delist the firm, Messrs. Sujala Industries. Then paragraph 3. The firm is advised to take necessary action as per clause 4.2.2.4 of the aforementioned ISO document. Inspection of materials against purchase orders placed under temporary delisting will continue to be carried out as per existing policy norms. Now, Lord, if it is a temporary delisting, Lord, they have to mention, Lord, the period for which the temporary delisting is being made. It can't be, Lord, a continuous delisting by way of a temporary period. And Lord, this, your lordships will find this clause based on which this temporary delisting has taken place is at page 278. 277, sorry. Starts at page 277.
Temporary delisting.
Temporary delisting. Temporary delisting of vendors can be resorted to under the following conditions. Cases where repeated failures are noticed, direction from law enforcing agencies, none of these are applicable. And in fact, your lordships will not find that any reasons are given. Any of these reasons are given in the body of the letter of at page 271.
Yes.
But your lordships will find this is an order which is wholly without.
When you take the instruction, come with the instruction. When you will come? 2 weeks time I will grant you to with regard to the filing affidavit. I will grant 4 weeks, but you have to come because they are asking for the interim order. So take instruction. Take instruction. They want the interim order. They are moving for the interim order. So take instruction. When you will come? How soon you will come?
Lord, what I am praying at the present moment to keep the delisting order in abeyance. And Lord, if my learned friend wants time, Lord, I don't mind. Kindly see my prayer G, page 52, prayer G. This is a temporary delisting order. This can be reinforced, Lord, if your lordship ultimately finds that there are grounds for this. Because our contention is that there has been no inspection of the materials based on which this delisting has taken place. G or H, Lord?
Yes. What is the submission? Come on. As per the prayer made by the counsel for the respondent, the counsel for the respondent prays for a day's time to take instruction. According case adjourned, let the matter appear on 27 under the same matter. Same position.
Within the first 10 minutes.
We appear for the petition.
Yes. Who is appearing for the respondent? State? You are appearing?
Yes. Marad, in this matter, Marad, earlier Marad heard, but after the order passed by your lordships, we have already served the others also, including the private respondents. Everyone. But earlier, Marad, I have. Yes.
Yes.
Already serving the instruction.
Where is the instruction? This one. सब मिला के दे देते हो यार.
কি হয়েছে?
Creation of the fresh tenders on the designated portal www. So you have changed the portal.
Yes.
You change the portal.
Yes.
Or website.
Both.
Both. What you change? Change the portal or change the website?
Which side? The portal.
Huh?
Malak portal.
Portal.
Mm.
Which portal?
The www.tenders.com.
Oh, that's what I'm telling. That is a portal or website? www.tender. That is a website or portal?
This is a website,
Then-
but
So pending the government orders and including the revenue, we are fully aware of the operational changes. No grievance was lodged by the bidder regarding multiple.
देखो 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 देखो
Yes. Tell me, what is the case?
Kindly give me some time for my seniors.
Huh?
For my seniors, he is engaged in
Dr.
court
Singh.
number 1. Ajit Kumar Misra. Just he is engaged in court number 1. Just now. Just 5 minutes.
Huh?
Just 5 minutes password.
Only page 48 minutes sees that is their memorandum. They should have given us time, and finally, before rejecting us for shortfall, they should have given us opportunity of hearing. Page 48 minutes. That is the actual point. That is their memorandum. Page 48. Thereafter, Marat, they have finally in the supplementary affidavit, they have admitted that representation ought to be considered. They have done a wrong, erroneous thing. They have not considered my representation regarding that, and so they will now consider it. That is the, Marat, I am placing the supplementary affidavit. This is my case. Supplementary affidavit is at page 13.
Yes. On the last occasion, the same question was put.
Page 13, they have said.
Once you are taking the decision, and second thing you are taking that the representation is.
So regarding the last occasion, the 7 minutes of factual incorrect.
Kindly come to the page 13 of the supplementary.
Of the supplementary, I have handed over there.
The last occasion you had appeared.
I have given you that copy.
What is your good name?
Mr. Gopal Krishna Sarkar.
Yes, you had appeared.
Yes.
I have
And you
given
have
you a
taken
copy.
time. Kindly come to the page 13.
তেরোটা দেখুন এই যে। They have admitted regarding technical evaluation and shortfall documents. Please be informed that your communication has been formally admitted for administrative consideration, examination. They have admitted this.
So what will happen?
Kindly allow some possible adjournment today.
Also. Next. Yes.
The bank concerned bank is a scheduled bank.
Which bank?
It is a South Indian bank. It is wrongly been, may I just be candidly, may I submit that it is a South Indian bank. It's wrongly been informed my friend that it's a national bank. It is, I found that it is a private bank, although recently, very recent, Rajasthan High Court also held several orders.
So what is a prayer?
Yes, prayer is not only decreasing my account, let me the disputed amount may be kept on.
What is the disputed amount?
Disputed amount is only 10,000.
Where is that?
Yes.
Where is the affidavit of service?
Affidavit of service, I have.
Have you served?
Yes, served, they received. Further notice was also served, and the bank manager also called me. He have been posted with the fact that this matter is going to be taken up. It is already was running in the Tripoli. That is the branch address. It has been received month of March.
Then, my lord, in July also.
March it was served, February,
So
March.
thereafter, in July also, after your lordship, my lord, allowed my mentioning, it was, my lord, again served, a notice was served, it has also been received. And my lord, these are the, my lord, communication. May I just place your lordship that WhatsApp communication from the bank manager and me. And I have yesterday also I have informed that your lordship was pleased to allow my mentioning, and he has been posted with the fact. Now he is informed me that I have delegated the matter to the legal team. We will post you. I say that it is being. I called him. It is long being posted. Matter
Yes.
is pending.
What is the matter?
Yes. Matter is, my lord, that on, my lord, 2023, sometime, my lord, September 2023, I found that bank remain inoperative. So I queried.
2023?
Yes, my lord. I have, for that, consecutively, my learned advocate is pursuing, keep the disputed amount on hold and make the other part operative. I had to, my lord, been to, and it is that from the query I came to know that the cyber complaint was from Gujarat, Sarthona PS. So I have been to Sarthona PS. The police station also, my lord, page 48. Also, it is in Gujarati language, my lord. In Google Translate, I could gather that they have informed me that they have issued no objection. My bank is saying no. They have, the PS has not send it to bank directly. They will not accept from me. They may place a query to the concerned police station. On the basis of their complaint and information, they frozen my account. But on the basis of they will not extend their any cooperation, whether this page 48 is genuine or not. Page 48 is the translated copy. So my humble prayer, keep the matter. I also requested the bank through my learned, sorry. Yes. I even, my lord, personally visited to Gujarat for all this, solve the problem of this.
Yes.
Yes. Can you see my email, page 49? I asked that you keep the 10,000 on hold, let me operate.
So since when your bank is there, your account is freeze?
Account is closed, my lord. I have, my lord, page 3, paragraph 3.
Since when?
Since, my lord, 13th September 2023. And your lordship's judgment is also there, my lord, that relying on, my lord, Malabar Gold and Diamond, your lordship, my lord, was pleased to pass this order. Very recent judgment of Rajasthan High Court, where, my lord, the Honorable Court, my lord, in various private banks also held that they have, my lord, the Honorable Court was pleased to detail explicit guideline.
The petitioner has filed the present writ application praying for a direction upon the respondent number 1, the South India Bank, Bardhaman branch, to defreeze the account of the petitioner. And advocate appearing for the petitioner submit that the petitioner is maintaining saving account or
the current account.
Maintaining a current account being number 0774073 6 times 0 293 with the respondent number 12 bank, respondent number 1 bank. On 13th of September 2023, all of a sudden the bank has freezed the account of the petitioner. When the petitioner came to know about the freezing of the account of the petitioner, the petitioner has contacted the respondent number 1, and the respondent 1 informed the petitioner that the account of the petitioner is freezed on receipt of the report from Sarthana Police Station, Surat City, Gujarat. Police stop. It was further informed that as per the said report of the Cybercrime Police Station of Gujarat, that the disputed amount of rupees is rupees 10,000. The petitioner, on receipt of the said
Information, the petitioner has visited the the police station at Gujarat, and the police authorities have informed the petitioner that the police authorities have informed the bank that the account of the petitioner may be allowed to operate by keeping the 10,000 rupees, which is a disputed amount, on lien. But in spite of the request made by the investigating agency, also the bank has not defreezed the account of the petition. For the last 3 years, the petition is not in a position to operate the bank account. The petitioner has filed the affidavit of service wherein it is found that in the month of February and March, the notice have been served upon the respondents, but none appears. Subsequently, when the petitioner has mentioned the matter in the month of July, again the petitioner has served the notice upon the respondent authorities, including the bank, and the notice have been served, but in spite of service of the second notice, also none appears. The petitioner has also relied upon the WhatsApp message, as when the petitioner yesterday mentioned the matter before this court, and this court has allowed the petitioner to allow that the writ application be listed today. The same was also informed by the petitioner to the respondent number 1 through WhatsApp, and the respondent number 1 had the knowledge that the matter will be taken up today, but in spite of the same, none appears on behalf of the respondent authorities, including the respondent number 1. Considering full stop. This court find that time and again the petitioner has served the notice, but none appears on behalf of the respondent authorities, including the respondent number 1, and thus this court has no other alternative but to take the writ application in the for hearing in the absence of the bank. At the land counsel for the petitioner, this court find that the bank has freezed the account of the petitioner in the month of on 13th of September 2023. And since then, the account of since then the petitioner is not able to operate the bank account. The petitioner has also approached the police authorities, on the basis of which the bank has freezed the account, and the police authorities have categorically informed the petitioner that the only disputed amount is rupees 10,000, and the police authorities have requested the bank to defreeze the account of the petitioner by keeping the 10,000 rupees, which is a disputed amount, on lien. But in spite of the same, the authorities and the bank has not defreezed the account of the petitioner. Considering the above, this could find that the disputed amount is rupees 10,000. But the bank has freezed the total account of the petitioner for the last 3 years. Accordingly, the respondent, the number 1, the South India Bank, Bardhaman branch, is the branch manager. Who is the branch manager? My lord. Branch manager, South Indian, and the respondent number 1, South Indian Bardhaman branch, is directed to allow the petitioner to operate the bank account of the petitioner by keeping the disputed amount of rupees 10,000 only. Next. Aya.
Yes.
In the entire document, no shortfall is given.
Yes.
No shortfall is referred. And my lord, if your lordship goes to page 2, waiver by participation, if your lordship gets their document, no shortfall has been given. What shortfall we have done? But
where is the rejection?
Page 42.
42 or 44?
Page 42.
42. 42.
My lord, kindly see serial number 2. Mukherjee lied.
Insufficient document.
Insufficiency of document. The report filed today does not disclose any such insufficiency of any necessary document, that which required document is not submitted by us.
It was when it was rejected?
It was rejected on 21st July 2026.
And when the work order was issued to the private?
23rd.
23rd July. Yes.
Page 45.
And what is the page 48?
Page 48 is the memorandum, the guideline of the department. That
supplementary.
Yes.
My lord, this supplementary affidavit which was filed by them, we have to deal with it, my lord.
It has been given to your learned friend on the last occasion. The last occasion he was present. it
Very
was
well, my lord. I will try to satisfy my lord on this score, my lord.
No, the only question is that kindly come to the page 42. This
My
is
lord.
the rejection, correct?
I am on that, my lord.
Insufficient document.
Insufficient.
It is rejection. Now you kindly come to your memorandum. That is page 48. It is your memorandum.
My lord.
Your memorandum says if any insufficient document, whatever the opportunity is to be given, whose technical bid has found to defective, explain their position within 7 working days. Correct. Their 2019 memorandum.
My lord.
If this memorandum is modified, that is different thing. If it is still there, then this was insufficient has been given on 21st of July.
My lord.
Correct. And on 23rd, you have issued the work order.
My lord.
Correct. And in the supplementary affidavit, you admitted that his representation is under consideration. If you have issued the work order,
My
so
lord.
what consideration you will do?
My lord, perhaps this is a mark copy. I'm sorry for that, my lord. If I place it, my lord. Already that has been communicated, my lord.
Because in the report also, what report your Leonard Pender's place that is also
My lord,
not disclosed.
that was an instruction, my lord, not report, my lord.
Yes, an instruction.
That
has
was
not
the
been
instruction, my lord. If my lord is having the copy, my lord can get a copy of the instruction. কোথায়? Where is the copy? সাহেবের কাছে আছে? Yes, my lord. That is we have, my lord. Answers to their reply.
Answer with, that's why I'm telling. So what?
No, my lord. To that effect, my lord. Our answer is, my lord. If my lord may kindly take page 2 of the said instruction, my lord, paragraph 4, my lord.
Shortfall notice.
Yes, my lord.
Yes.
The e-procurement platform automatically generates a real-time SMS and email alerts to the registered contact details at every evaluation milestone, technical acceptance, rejection, financial bid status, and shortfall generation. Non-receipt of these alerts stems from bidder oversight. In addition to the automated alerts, the departmental computer operator telephonically informed the petitioner regarding the shortfall notice, mutually discussing the compliance timeline. Now, my lord, under extant procurement rules, bidders may only upload pre-existing documents valid prior to bid closing date. Against a shortfall notice, generating post-dated document is strictly the petitioner claim of lack of notice or prejudice is not sustainable, my lord.
So
now, my lord, the second part, my lord, kindly takes 5. Kindly takes 5. Adherence to technical and financial, the timeline gap which my lord is referring to, my lord. No fixed time gap between technical bid, opening bid, and financial opening bid was mentioned in the NIT, my lord.
No, not that. So what?
And now and sequence, my lord. My lord, kindly takes the second line. Sequence, my lord. This is, my lord, I cannot improve the record. This is all I have. Now, my lord, a complete 24-hour window was provided following the shortfall compilation end date before finalizing the technical evaluation. A further 24-hour interval was maintained prior to opening of the financial bids.
Correct. So that's
So, my lord, their claims that it is within 7 minutes, this is not tenable, my lord.
No, not 7 minutes. No, I am only on that. If you are taking this is online. So this is online process.
Yes,
the
my lord.
Bidding process is online.
Yes, my lord.
Correct. So if the bidding process is online, this is on 3:38 p.m. It was rejected. If page 42.
Yes, my lord.
Page 42, his insufficient document 3:38 p.m.
Yes, my lord.
Correct. 3:38 p.m. If the 3:38 p.m. and so whether you have superseded the memorandum dated 14.
My lord, for that kindly takes it up tomorrow, my lord. We will take instruction. Only this part, my lord, which my lord is referring to, my lord, kindly allows me to take instruction and come back tomorrow, my lord.
Because if you have superseded this,
no.
If you have superseded this, then you have to come with the, because see, if you directly you are conducting the e-process or through the GEM or
No, my lord. I think it is, there is a portal run by NIT, my lord. NIT.
Correct. So NIT portal, if you have submitted the document is not there, automatically it will be rejected.
My lord, since the technical bid was not complied with, so it was not our answer, my lord. It was stated, my lord,
that since that technical bid was not disqualified at technical stage, my lord, the financial bid remained encrypted and unopened.
Correct. Naturally.
So part 1 did not qualify, so part
That's
2
why
they
the-
could not
That's
avail of.
why the part 1, because now contradictory has come. The shortfall, because now you are asking about your report is your whatever the instruction is, that is with regard to the e-procurement.
Yes, yes, my lord.
E-process.
My lord, my lord.
Correct. And the memorandum which the petition is reliant upon page 48, that is, I think it is a physical.
Physical.
So,
So, my lord, kindly allows me a day's time, my lord. Tomorrow, kindly take up tomorrow. In the meantime, we will take only this which involves the issue, my lord. Kindly fix it up tomorrow.
My lord, page 30 of the certificate, they have said they are considering
So,
again.
since
They
my
have admitted.
No, that's
there is
Now
no
they have
admission on
admitted.
that part,
Yes,
my
it
lord.
is an admission.
My lord, it is my learned friend's submission that it is
What
not admission.
submission? Your submission.
Only that part which has fallen from my lord, kindly take.
That is also not, if it is rejected and you are under what consideration you are doing, that also consider. Why you are giving.
My lord, on both the issues, I will satisfy, my lord.
After issuance of
Council for the state has filed the instruction, but this court find that that is not sufficient to deal with them. But then counsel for the petition has placed the instruction on record, and he further prays for time to take further instruction. According cases adjourned. Let the matter appear on Monday.
Any days, my lord, subject to my lord's convenience.
There is a short, let there be a short stay there.
No, my lord.
No, there should be.
Everything, my lord. My lord,
No,
this is a
everything what? You have taken instruction. You have not taken instruction. Now also you have not taken instruction. Now there
Monday,
is a
my
short stay.
grateful, my lord.
Short stay, but there must be a short stay.
Monday. Grateful, my lord.
Monday, but let be a short stay.
Yes, come on that. Monday I am
Let the
keeping
matter be
it.
disposed of on Monday.
Work order is already.
Proceed or further proceed. That be there.
Work
Otherwise, they will say they are.
That's a temporary. They have issued a temporary. Let the court will consider. Yes, come.
Monday, my lord. Grateful.
Then that will abide by the data. That will be.
Automatically, I am here. I am hearing.
If my lords decide against me, then everything goes, my lord. Nothing remains, my lord.
Let they come. Yes.
Grateful, my lords.
11 or 12? It's a PO.
My lord, in this matter, I'm on behalf of the petitioner, my lord.
Yes.
As to my lord's order, last question, supplementary affidavit, my lord.
What is the matter?
The matter is, my lord, petitioner successfully placed her place in JE and NET. The domicile certificate was not issued by the.
Who is for the state?
Lordship, I am for the state, Lordship.
Yes. What is the guidelines, madam, for issuance of the domicile certificate?
Lordship, I got the instruction from the department, but that is not sufficient to deal with the matter, Lordship. As per my knowledge, domicile certificate.
Counseling. Yes, counseling is going on. Huh? Yes, next week is the last date, and tomorrow is the holiday. What is
Lordship,
the
Lordship, as per guideline, 10 years resident must be 10-year resident or 10 years or any address proof for residential for the issuing for the certificate or schooling at least on that jurisdiction schooling must be at least 10 to 12 years like that, Lordship. I have. At the present time, Lordship, I have no guideline rules or book, Lordship. Kindly fix it on Thursday, Lordship.
Thursday, all matter cannot be fixed.
My lord, it is my father was doctor. He was
but petitioner parent's name is not reflected in electoral roll, Lordship.
Just a minute, electoral roll has been deleted. That's why I'm asking you. If the father's name has been deleted and the daughter has completed the total school, how you can deny that?
No, Lordship, we don't deny, Lordship, but we don't have the options, Lordship.
In West Bengal for the last several years, and the daughter's name is still there in the record, and she has completed the total schooling in the West Bengal. So how you can say?
No, Lordship, at that jurisdiction. At that jurisdiction, petitioner not completed the school.
You learn the voter list. What is the voter list?
Lordship, kindly fix it on Thursday or Friday, Lordship. I will take the all instructions, Lordship.
Document is there, my lord. Or even I have My name is also electoral list over there.
Correct. The petitioner's name is electoral roll. So why you are insisting on the father's name in the electoral roll?
My father's
You
died.
have you allowed.
My father's died. My mother's name was deleted. My father's died, my lord. Kindly came to page number 29 of supplementary list, my lord. My father's Aadhaar card, voter card, everything is there. Our father was
In 2002, your father's name is in the voter list.
Father
2002.
Yes.
When the father died.
2017, my lord.
2002 his name is there. Father's name in the voter
No,
list.
lordship.
It was I have
No,
don't have.
no, lordship. No, lordship. As per
My name is there. In
Your
the
name
page-
is there.
My lord. Page number 76.
Page?
Page number 76 of the supplementary list, my lord.
Yes. Her name is there. Her or he?
She.
She. Her name is there.
lordship, but parental name is not there. That's why department not allowing her lordship.
That is the
Lordship, in
guideline.
fact, I have lordship kindly fix it on Thursday or Friday, lordship.
Today.
I will satisfy my lordship.
Within 5 minutes.
Lordship.
Yes, next. Yes.
Yes.
Who is for the petitioner?
I am for the petitioner.
Yes.
Should I appear for the respond number 224?
To director to file report along with a plan with regard to the Kalyani Barakpur Expressway and also to clarify whether there is any alternative arrangements with regard to the egress and egress of toward the petrol pump.
Lordship, we are yet to receive a copy of the supplementary affidavit that they filed on the last date. They were directed to serve.
You are appearing for whom?
Respond number 224, West Bengal Highway Development Corporation.
Okay.
My lord, we have
Lordship,
served,
we'll
my lord.
file a report. Let them give us the supplementary affidavit by today. We will file a report.
My lord, we have already served the soft copy.
Today, right now, your lordship.
And other parties, upon the other parties, we have already served.
224 you are appearing.
Yes.
So you have to submit the report.
I will submit the report. Let them file. The supplementary affidavit is sent to me today on WhatsApp right now in court.
Give the copy.
958 after 956. Yes,
The petitioner has served the supplementary copy of the supplementary affidavit to the London Council for the respond number 224. Respond number 224 prays for time to file report in terms of the order dated 1st August 2026. Let the matter appear on 7th September.
grateful, my lord.
Next.
My lord,
39 for the petitioner, my lord.
analogous matter, 12 and 14.
This is a matter, my lord, pertaining to bank freeze, my lord. Only 50 rupees is, there's a difficulty with rupees 50 at page 44.
Lordship, I appear for
Yes, who is
respondent
appearing for
number
13? Who is in 13?
But we have served all.
And appears on behalf of the petitioner. Let the writ petition be dismissed.
Well, I am for the petitioner, my lord. Item number
I am asking who is
13, my
appearing.
lord. But I am.
Yes, what is the case
But
about?
page 44 is the only rupees 50. Praying for defreezing of the account, my lord. I am covered by your lordship's judgment.
Item page
44 and 46, my lord. 44 is the bank lien which they have disclosed only rupees 50.
Yes. And 46?
And 44 is the passbook entry, my lord, showing rupees 70 is the bank transaction that is there. We have issued representations, my lord, that has been not been considered by the bank. And my lord, I am relying upon your lordship's judgment, which is patently, squarely covered, my lord. Karnataka police involved.
Page 46, which part you are relying upon? Page 46?
It's 11 from the bottom 11.
Where is that transaction of rupees 50? Where is that? 24, 522. Where is the 50 rupees? Where is the 70 rupees? What is the 50 rupees?
50 rupees that is at page 44. Matlab, the Finacle records that. That bank lien cyber 50 rupees.
Who is appearing
But
for the?
left hand side column, matlab, cyber.
This is a cyber. Where is your account detail 50 rupees?
And page 46 is my passbook entry, matlab.
That's why I'm asking, sir. I know 46 is a passbook entry. Show me from the passbook entry with regard to transaction of rupees 50 on 24th May 2025, which you are relying upon the page 44.
Yes, matlab. May I humbly submit, matlab? In the passbook entry, on the self-same date, that is on 24th May, matlab, the entry is rupees 70. That the 50 rupees becomes 70. There is no entry of 50 rupees, but there is an entry of rupees 70, matlab.
Bottom 11.
Yes. Who is appearing for the bank?
For the bank, there is a third party at least for the third party.
Huh?
And from my instruction that upon the instruction from the company operator,
Show me the law. Show me the law for the 50 rupees. You can freeze the total account of 1 crore. Show me the law. Or tell your bank manager to appear before this court in person. Either show the law or show the person.
Upon the instruction for the company operator.
That's why I'm telling you are the advocate. If you are taking the instruction, you take the instruction in accordance with the what? What you have done for 5 years. Books. If you have pity, your bank will come, sir. Yes, he has murdered. He has murdered. Hang. 50 rupees and you have seized the total amount. How many months it is freezed?
But it is pending for more than 1 year, matlab.
1 year.
And I'm not being able to operate it.
1 year. So what was the amount lying in the?
Matlab.
I'll pass an order. Give the interest of rupees 15% per annum of the total bank account which you have freezed for 1 year. Well, you show me law, I will allow you. I will give 1 hour. I will hear you. But you have to show me under what provision of law for the rupees 50 you have freezed the account of the petitioner for a year. Show me.
I need to take the instruction for the mail that we have received from the company operator. For the instruction, the mail from the company operator.
What the investigating of? Have you received any further other than the 50 rupees? Have you informed the petitioner? What you have done after receipt of the representation of the petitioner? Audio alternatum, you know. Opportunity of hearing, you know. Then this is the relation you are keeping with your clients. That's a commercial bank. The petitioner has filed the present date application praying for decreasing the account of the petitioner. The petitioner is maintaining which saving account with the Bank of Baroda Canning branch, South 24 Pagana, being account number 422481000611019. Full stop. The petitioner submit that on 24/5/2025 on receipt of the report from the cyber crime police station. Which area?
Bangalore.
Karnataka police has indicated it.
Karnataka police.
But I am a resident of Canning.
Karnataka police, the bank has seized the account of the. When the petitioner has contacted the bank authorities with regard to the seizing of the account of the petitioner, the bank on the petitioner that the bank has received a report from the cyber crime branch of Karnataka with regard to the disputed transaction of rupees 50 in from the account of the petitioner on 24th of May 2025, the bank has freezed the account. The petitioner submitted subsequently, the petitioner made several representations to the bank for releasing of for defreezing the account of the petitioner by keeping the rupees 50 in lien on lien, in spite of receipt of the request of the petitioner, the bank has not considered. The petitioner has also requested the investigating officer, investigating agency for submission of the report, but in spite of the receipt of the request of the petitioner, investigating agencies have also not submitted any report whether the account of the petition is further required for the investigation. Land Counsel for the bank submit that the bank has account of the petitioner on receipt of the report from the Cybercrime Police Station of the Karnataka with regard the disputed transaction of rupees 50 rupees. 50 rupees. Yes, madam, you are appearing for this.
I'm for the state lordship. I don't have
nothing to do. Police stuff. Police stuff. Had the landed counsel for the respect, this court find that for since 24/5/2025, the account of the petitioner is seized by the bank only on the allegation of disputed transaction of amount of rupees 50 by the Cybercrime Police Station of the Karnataka. Considering the above, this court find that after the month of May 2025, there is no allegation against the petitioner that the police authorities have made any complaint against the petitioner or any further amount on further transaction of the amount from the account of the petitioner. Considering the above, the writ petition is disposed of by directing the respondent number. Directing the respondent number.
But the branch manager
9.
Canning branch manager.
Number 9 or any other competent authority of the Bank of Baroda Canning branch to allow the petitioner to operate the bank account by keeping the disputed amount of rupees 50 in lien. Disposed of.
One small variance undertaken to file.
Fine in the department.
Grateful.
Next.
Same as item
Same
number
as
12.
that, yes, my lord.
I'm for the statement.
My lord, I appear for the respondent number.
Yes, next.
My lord is keeping it on
same day.
Fine.
But within top 10 matters, my lord. Within top 10 matters.
Within 10 minutes further. Yes, next.
My lord, item number 15. My lord, item number 15 in connection with the registration of deed. My lord, I simply pay before your lordship. There are so many anomalies, my lord. Apart from that, I am paying for consideration of the representation annexure P18. I have prayed for madam after the direction. Let it be considered because my lord, your lordship, the last occasion has passed the order that 2 suits are pending. No, 2 suits. No. 1 suit is pending. That is annexure, my lord, P16. That was P16 or P17. P16 or 17. My lord, what happened? Thereafter, 1 suit is pending. My lord, that is in relation with the go down, which is not at all connected with the payment of the consideration of that. My lord, the last occasion, I am fairly submitting, my lord. It is not that whenever is not present, I am not. Because on the last occasion, he has submitted an agenda, but it is completely disputed. Kindly see for a moment. Why I am praying for representation consideration, it will be decided there. Let it be sent there. Because, my lord, a dispute, page 27. First of all, this is an agenda, a Xerox copy of the agenda, somehow collected. Thereafter, my lord, page 27. What about this? Is it not a resolution? It is not a resolution. My lord, thereafter, my lord.
Yes, continue.
Yes, my lord, thereafter, on this viewpoint, my lord, he has said not to make registration on the reservoir amount which is taken on the basis of the order in modification of the earlier order. My lord, kindly for a moment see.
Correct, sir. See, you have already filed a suit with regard to your right toward the property and restraining the authorities for disturbing your possession. Correct. And perpetual injunction, permanent injunction, whatever it may be. Correct. Now your deed is there. So you are telling that they are not executing the deed because they have already taken the decision, you deposited the amount. So now they are disputing, okay, with regard to the first part, they are admitting that, yes, with regard to the second part, they are denying that. So that cannot be decided in the writ application. You have already initiated the suit before the authority.
Let it be decided by the representation consideration.
Representation, how if the same thing will come to the authority before the registering authority and the KMC will say that no, we have not sold this part of the, so how the authority
No,
will
my lord,
register
kindly
that?
see. Annexure P7, kindly see. In modification to this office memo number.
That's why.
Thereafter, my lord, thereafter, what it is, that is Annexure P6, related with the P6. Related with the P6. And at the time when they oppose, they only says the suit pending. Now suit pending. And whatever documents placed where it is completely disputed, then affidavit is required. Otherwise, affidavit is required.
Okay, let the file affidavit.
My lord,
If you
I
want
say,
if you want the affidavit to decide, let the file affidavit. Let the matter be kept pending for the years together.
My lord, let it be sent to the representative.
I am not satisfied. See, you are claiming the two parts of the property. One part they are admitting, one part they are disputing. First thing. Second thing, you have already initiated the two cases. Correct. Pendency of the suit, you have also obtained
one suit, my lord, one suit.
Two cases.
No, my lord, one suit.
You have also
kindly see page.
You also prayed for the interim order. In the suit, you are praying for your perpetual injunction and permanent injunction, whatever it is. So how the authority will decide the issue which is pending before the civil court?
My lord, one suit, kindly see. No, one suit, order one suit, kindly see page 15. Page 15. Sorry, P15, page 49. One suit. Page 49, annexure P15.
Okay. Okay, you want to argue, then I will hear the authority. And what is about page 35?
Page 35.
Yes, page P12.
That is regarding the VAT, my lord.
This is also suit?
Suit, but not disputing.
What disputing?
No, they are not disputing.
What?
They have only disputed just titles.
That's why I am telling there are two suits. There are two suits.
Yes, my lord.
Then
one suit is both the suits, my lord, connected in front of the hotel restaurant, which is completely impossible going on to run the hotel. My lord, knowing fully well, there was a garbage, there was a go down. My lord, I can show the video record before your lordship regarding the brick wall in front of the ingress and egress of the hotel. Therefore, my lord, either let me affidavit, if you kindly represent the consideration, my lord, it will be within 8 weeks by the referendum. It will be clear to the respondent authority.
This court finds that the writ petition is disposed of only after exchange of affidavit. Let affidavit in opposition be filed within 4 weeks. Reply, if any, there to be filed within 2 weeks. This after 6.
My lord, the matter will appear
after 6 weeks.
But if they are agreeable to withdraw, my lord, then as it had fallen from my lord on the last occasion.
Yeah, he has not opted that.
He is not opted for it.
No, it will be difficult, my lord.
Okay,
at this stage,
come with the affidavit.
Withdrawn, then they will again. We are ready, also ready. My lord, my lord,
the options were very clear, my lord, on the court.
Plot, what amount he has taken, because if reservoir is out of
the rest can be decided in the suit. That's a disputed issue. That can be decided in the suit, my lord.
Okay. Next call the matter. I'm for the petition. Yes, what
On
is
the
the
last date, state has submitted for instruction to submit today itself,
But
but
will not submit. You start your case. I will dispose of the matter. If the state will not appear, I will not, because on the last occasion the state appeared. Takes time. Today nobody is there. So what you continue.
my lord, this read code, honorable court has the.
What is the prayer?
My prayer is to take the suo motu jurisdiction, cognizance under Birds Act.
What you prayed for? Constitute a court under section 8 of the Birds Act.
Yes.
And to appoint a competent authority under section 7. Yes.
If state is.
Who had appeared for the state? Can I know? Who is the advocate?
Sudeepa.
Sudeepa. Very well, my lord, I shall appear, I'll take instruction.
That is the problem with the state, madam. Now today you are appearing, now tomorrow again will come.
Sudeepa will be there.
Sudeepa is never appearing there. One day appearing, second day when the court call for the report, she after opening the door, she will flee away from the court.
My lord, I shall appear.
This is the attitude of her.
Yeah, this is not good, my lord.
When she appeared, she will take the writ petition from the authority, from the petitioners, and subsequently she will say that I will come with the report. When the date is fixed, the report, she will not appear. And another advocate will come. The question is that whether the authority have constituted any court under section 8 of the Birds Act or not. This is the only question. And the petitioners are coming from the outside. On that day, it was informed. They are coming from Madras.
Not fair, my lord. Kindly take it up on Friday, my lord. I will be able to take instruction.
Not possible for me.
Huh?
Not possible Friday, if it is fixed on Friday.
This is only if you say no, it is not.
My lord, kindly take it up around.
No, if you say that it is not constituted, then the court will pass an order. If you say not able to constitute, then the court has to decide. There are three things.
One thing, my lord, kindly take the matter at 2 p.m. I shall take instruction, if possible, by system. Because he has come from outstation.
That's why I'm telling.
Yes.
On that day, in her presence, the case has been, she told that she will take the instruction. 2 p.m. I don't think you will be able to.
Because he has come from outside.
When you will have when you will available, when you will come?
September first week.
September first week,
before,
which date?
Before.
Come on 10th? 9th or 10th?
9th.
Yes, madam, you take note of it and come on
I'm
with
just
the
taking
instruction.
the course that will note, my lord.
Land Council for the State Press will take. And Council for the State Press for time to take instruction. Accordingly, case adjourned. Let the matter appear on 10th of September under the same meeting within 10 minutes. Next.
My lord, in this matter, my lord.
My application, my lord.
State, my lord.
Same heading, but.
My application, Lord.
State.
Yes.
Lord, here they wanted to take instructions twice and they've come back today. The issue is very short, my lord. I've been blacklisted in respect of a work order.
I have contacted the authorities concerned, my lord. Vival Technology Limited, my lord. In fact, I have contacted with the concerned senior officer also. But as yet, I have not received instruction, my lord. But, my lord, in fact, there was no latest on my part. Kindly keep it on Monday, my lord.
Vival Technology.
Yes.
It is here only.
It is here in the new town.
My lord, there is no instructions to take any further. There is a blacklisting order that has been issued, no show cause issued, nothing in respect of an alleged contractual failure. I've been blacklisted by the respondent. There's no further instruction. My lord, I gave an offer to supply DSL cameras and other equipment. The offer was valid for 10 days. After expiry of 10 days, they issue the work order. I write to them saying this is after 10 days, I have no obligation to service this anymore. Then they issue a show cause notice saying why penal action should not be taken, and then they blacklist me. This is absolutely contrary to your lordship's judgments that for a contractual dispute, it can't. This reminds me of.
On Monday, if I don't get his, your lordship will direct so cause not.
As per the prayer made by the Council for the State, the case is adjourned. Let the matter appear on 1st September under the same heading.
It will retain its position, my lord.
Within 10.
Very well. My lord, one thing may I request for? that in the event no instructions are there, that day your lordship will hear them, this one, that much.
If it is made clear that if no instruction will submit by the state, the matter will be taken up for hearing without any instruction by the state.
Very grateful, my lord.
This is the LIC matter.
Yes.
Affidavit.
Last occasion, my lord, I have submitted the exception and I'm led by Mr. Vikas Ranjan Bhattacharya is probably appearing to virtual mode.
The grievance was that despite expanding the time period for their evaluation, still they would be prejudiced.
As per the rules, it would be a minor penalty, my lord.
Have you got the report?
My lord, I have got the report. I have placed the exception last occasion.
File the exception?
Yes, my lord.
Yes. Yes, what is the matter?
My lord, as per their report, my lord, they are extending the time period for the appraisal year. My lord, as per the rules, there is no scope to extend the time period. And my lord, it's only extend the time periods when there is a dice run or the employees are going on strike. So if they extend the time period, it falls under the minor penalty, my lord.
Show me the rule.
My lord, kindly takes up rule 39.
We have enclosed the rules. Yes.
My lord, now kindly takes up rule 2D of special rules definition of appraisal year. There is no scope to extend.
To
2D.
Appraisal years. Means the
It
period
is,
between two consecutive
two
appraisal
consecutive
years.
Appraisal date.
And the period of 12 months of service proceedings to the appraisal date ascertained in accordance with item A of clause 1 of clause C, and each period of 12 months of service next proceedings to the appraisal date ascertained in accordance with item A clause 2 of clause C. And yes. So means two consecutive appraisal date and the periods of 12 months of service proceedings of the appraisal date ascertained in accordance with the item A. A is the first year of his service from the date of publication of the rules in the Official Gazette of the first day of the month of following, which he completes the period of 12 months. So when they complete the 12 months, on the very first day, that is the first appraisal year.
The very next month, first is the appraisal.
Correct. Then,
now, my lord,
what is the difficulty here?
My lord, if they extend the time period, my appraisal period will be extended.
What is the contention?
My lord, my promotion.
Appraisal year. So appraisal year, how the appraisal? This is 1-to-1. So there is any prescribed this type of this work is to be completed within 1 year. Any point is given or what is that?
Yes, my lord. If in a particular appraisal year there is fixed target. There is a fixed target.
Fixed target. That's why I'm telling.
If I cannot complete that target, I have to face penalties.
Correct.
Now, my lord, if today my
so that's why say one financial year, what is the minimum target? Avoid the punishment.
My lord, it depends.
What is the minimum target to avoid the punishment?
My lord, it depends upon the cost ratio.
Huh?
It depends upon the cost ratio of individual employment.
Correct. Correct. So how you have been affected? Which order you have been affected?
May I just, we cannot, fulfill the target which is required for the purpose of my promotion and security of the service. The target is fixed annually.
That's why I'm telling what was the target and how what target you have achieved, leaving aside the election period, election duty.
That details, then you have to file an affidavit showing. Otherwise, that details are at the moment not available. Whatever that is necessary, for accepting those 3 months, let that be considered for the entire year. I don't mind.
That's why I'm asking if what is the shortage for which you have been allowed to continue for the next year. So yeah, if as per your contention, if it will allow to continue to complete the target for the next year, so this would be a minor penalty.
That is the service rules. They say if I fail to complete the target, and naturally business trend is during the conclusion of the year, the drive is more.
Correct.
And then we'll try to really coop up so that there is no fallback. But if the 3 months period is taken out, if they say that the 3 months period will not be considered, we have no difficulty.
Yes.
There is a issue that who is the development officers? Development officer is basically for LIC who are collecting business for LIC. Now, LIC is one of the topmost financial institution in India having a business of 52 crore lakhs. Now, the issue is, what is their job? Their job is to collect money from the public. Now, my lad, kindly see which rules they are under control. They are under the rules of, my lad, kindly see my affidavit in page 8. This is the insurance corporate LIC development officer revision certain terms and condition rules, which is in page 8 of my affidavit. This is the rules by they are governed. Kindly see rule 2 definition. Here in definition, annual remuneration, then appraisal date, then kindly come next page is a cost ratio. Very important subject, cost ratio. What is cost ratio? Cost ratio is basically this gentleman who is a development officer appointed.
Cost ratio?
Yes, cost ratio is kindly see 2E. Cost ratio means in relation to a development officer means the ratio which is annual remuneration in any year bears to the eligible premium of that year and expressed as a percentage of such eligible premium. For example, what is cost ratio? I am clarifying. Cost ratio means, my lord, suppose he is collecting annual premium rupees 100 and my lord, his eligibility of salary is rupees 60. That means he is collecting 100 rupees and his salary is 60 rupees. Now, my lord, the annual premium he is collecting 100 and the paid money which LIC is paying to the development officer is 60. That means 100 by 60 is the cost ratio. My lord, for example, they have taken a point of one Bidyut Mondal in their affidavit. Now, the issue is his prescribed expense limit is 19% according to the rules. My lord, he is eligible to collect premium to the tune of 52 lakhs something odd, but his salary is 15 lakhs already we paid. So, my lord, cost ratio for him is basically, as per law, is 19%. He got 28% according to our calculation. Now, my lord, he is getting more than what is eligible. Now, what happens? During the period of 1 year, we are calculating appraisal report. Now, appraisal report is also, my lord, clarified in our this particular rule. My lord, kindly see 2D. The appraisal year means the period between 2 consecutive appraisal dates and the period of 12 months of service preceding the appraisal date ascertained in accordance with item A of subsection such and such. So, my lord, X is appointed in January. His appraisal date is something different. Y is appointed in February, so his appraisal date is different. Now, the issue is during the 1 year tenure, Election Commission asked some people to be deployed there. Now, we sent 1,206 persons from LIC. We suffered huge loss because of lack of persons. Now, my lord, what we have given them, suppose X is appointed in the month of January His appraisal will be end in the 10th month of December, 12 months. Now, in the month of November, he had gone. So November and December, he had given service to Election Commission, for which they didn't pay anything. We paid something money to them. Okay, you are going to Election Commission, we are paying some money, although there is no service. Now we are extending this January to December for further 2 months extra for them, so that they can perform well. Now, because of 2 months less, as because he has joined to Election Commission, we have given 2 months extra to them, so that his appraisal report will be perfect. Now, my lord, kindly see in the table of expense limit. Here, in page 9, the table of expense limit. The development officer in the left-hand column, if the development officer is working in operation area, percentage of eligible premium is 19%. Now, my lord, they have taken an example of one Vidyut Mondol. Now, he is eligible to get 19%. Here, he collected 52 lakhs. We have given him salary to the tune of 15 lakhs odd. So, his cost ratio is 28%, which is more than 19%. So, he's not eligible to perform in proper manner according to the rules and regulation, even after giving them 2 months extension. Because he has gone there, so I have given 2 months extra to them, so that he can perform well. As because he failed to perform that performance, we are taking steps. Now, what steps we are taking? For example, Vidyut Mondol, they have taken example. We are saying, you are hereby given an opportunity.
Where from your reading?
Yes, this is after their affidavit. This is my instruction I received. I am giving it one copy to Malat. Malat, kindly see the last page. Last paragraph, rather. We are giving him an opportunity that you give a clarification to us. Nothing more we are saying. We are not terminating anybody.
You are given an opportunity to confirm.
Yes.
The representation in writing 15 days to receive this letter figure relating to a performance in the relevant appraisal. Here is stated. In case you find that the eligible premium not been properly computed, necessary for you to point out. Yes.
So what I'm trying to convince this court, we are not taking any steps against the employees who cannot perform well because they had gone to election commission. Forget about they had gone to election commission. We had given them 2 months extra. Still, they failed to perform well in accordance with the provision of the framework of the law. So we are asking them to give a clarification. That is the step we have.
If suppose they will give the clarification, and it is found that due to this 3 months they could not perform up to the mark which you want. Correct. So what would happen? That is the apprehension of the petitioners. If you are asking this, suppose
This is the crux of the matter.
they have been given 3 months or 2 months of the election duty. They could not go to collect the premium, whatever it is, or to
So
join.
we have given them 2 months extra.
That's why that's why I'm telling. If this period, if they have not collected, so now they are apprehending. Now you are giving the 2 months extra. So if the 2 months extra, so what from which year you will take the appraisal again?
Now,
If
my
you
lord,
given the 2 months extra.
My lord, kindly see, according to...
If it is January to December,
Yes.
in the month of April, the election has held. April to July, they could not perform the duty.
What happens, my lord? According to our law, kindly see page 15 of the rules of 2009. In the rule said, rule 9, kindly come to page 15.
Yes.
Kindly see, in the case of a development officer who has been confirmed in service of the corporation on a date prior to the date of publication of these rules in the official gazette, the percentage mentioned in sub-rule 8 above shall be increased by the appropriate transitional concession, and it shall be as under. What happens? The service of a development officer shall be liable for termination in accordance with Rule 7 if his annual remuneration in the first appraisal year commencing after the date of publication of these rules in the official gazette exceeds 50% of the eligible premium in that year. Accordingly, my lord, I am stopping here. Then, my lord, kindly come, paragraph B. The service of a development officer shall be liable for termination in accordance with Rule 7 in its annual remuneration the second appraisal year. So I am giving first year a scope, no termination. Then I am giving second appraisal report for the second year. Then, my lord, kindly come to
You cannot impose the condition upon the petitioners. Yes, you had been to the census work. Now you have to complete this target again for the 2 years.
Yes.
If I am the agent of the insurance company, correct? I have, as per your proposal, if a development officer, then I have to take take the venom or to the persons has to be included in the life insurance. Suppose 50 lakhs in a year. You have given the target, but 3 years I could not work as your LIC agent because of duty in the election.
They are not agent, my lord. They are development
If
officers.
suppose I am telling,
okay,
a simple case, if that, and this 3 period, because of the 3 months, I could not get the target of the 50 lakhs, correct? So you are telling that yes, you are not targeted, you are only the 38 lakhs, the 12 lakhs is to be completed for the next 2 months. This is a simplicity.
Yes,
I am
yes.
telling. Just simplicity. 2 months. If he will go for the 2 months for completion of the 12 years, so what would be the appraisal for the next year?
That's why, my lord, I have written a letter to them. Kindly give a clarification to us.
I appreciate clarification. If the clarification
We are
is
not terminating anybody. We are
not
saying
termination. They are not termination. They are telling that the same they are apprehending. Admittedly, they have not completed the target because of the 3 months, 2 months.
That is the
45
question.
days. That's why.
Yes.
So they have not completed. So that is admittedly. That's admittedly, and it is not the condition when the election commission has given the duty also to complete the target and also to.
We are not saying to them that
Just
you
a minute,
perform.
just let the code complete. So they have not completed the target. So you have not completed the target. Now you are taking the benefit of the rules of the insurance policy company. So you are telling that within the appraisal year, 1-to-1, whatever the July to July, January to January, whatever, he has to complete that. If he has not completed, now you are telling that yes, 2 years grace period has been given to complete that target. If you are giving the grace period to complete the target, no problem at all. But what would be the next financial year? That they will be back or they will not complete the next financial year? So for the next financial year, they will not complete, then they will be liable to be punishment.
That's why, my lord, the letter the authority has written to one of the employee, which they have produced before this court, that we are saying to them that due to the extra time we have granted to you, still you fail to fulfill the target. Hence, you give a clarification.
I am not an extra time granted. Okay, you have granted extra time. That extra time was the next appraisal period. Next appraisal period. If this extra time is, they will take the benefit of this extra time. So what would be the next appraisal period?
First,
they cannot complete the next appraisal
what
period.
happens? They have gone to election commission for 2 months. So we give for first appraisal year, for example, 2 months extra we have given. Then the next appraisal second year will be normal year.
That's a normal year. But you are telling that for the next appraisal period, you are giving the 2 months grace period to the
first appraisal year. This one.
That's why first appraisal is completed. So second appraisal period is now you are giving the grace period of 2 months.
Now we are asking a clarification from them. Can you fulfill?
Why don't you say that there will be no penal action for joining election? Simple thing.
We are not terminating anybody.
Not,
we are saying,
okay,
if you
I
try to fulfill it.
I will clarify. If you will say If they will complete the target or not complete the target, but they will not be affected for the second appraisal period.
Yes.
You give that, I will record that the matter.
There is no scope of extra time given for the second.
Then
Not second, I am telling. So that's why I'm telling. The problem is that you are giving the extra 2 months or 3 months.
Yes.
So extra 2 months or 3 months of what? The second appraisal periods covering that
Yes.
period. Correct.
No. That thing will be not covered.
Why not covered?
My lord, for example, January, suppose he appointed in January 1. So his appraisal report will be started from 1st January next year. So within that period, he was not in LIC for 2 months. So we are giving them 2 months extra. That means 14 months time he is getting. Now next appraisal time will be start from after 14 months. Another 12 months from 14.
So they will be back. So if you're giving that, so they will be, their seniority will be affected. So they will be back for the 2 months. They will be back for the 2 months. If suppose the January ends, correct, and you are giving the 2 months, that is the 14th of February 2027. 2027. So you are starting the next appraisal period from the February 2027 to February 2028. Correct. So if the development officer who has not gone to the duty of the election, their performance, their appraisal period remain in the January. So they will become the senior. Their seniority will be affected. Then
the issue is not that. Issue is during the span of 14 months, they fail to fulfill the target cost ratio.
That's why you are harping upon your target. They are telling that, okay, whatever the target which they have achieved, that has to be accepted by, but their appraisal period cannot be reduced.
Unless
Whatever we are coming to learn, whenever the matter is
promotion is not possible, my lord. Because we are within the periphery of the rules,
so that's
and we are binding on that.
Directly or indirectly, again it has come. You're telling that if they have not achieved the target within one year period, so they will not be promoted. That's why you have given the 2 months period. If the 2 months period, they will then, if they give the 2 months period, it will be 1 year appraisal period of the treated as a 14 months, then their seniority will be again defeated.
This is a normal system of law. Malat, kindly appreciate one thing. If somebody was not promoted in proper format, they'll be junior, including the judiciary also.
No. It is, suppose in the leave aside judiciary, you go to the teachers, because the teachers are the very persons who have firstly targeted in every work. If the teachers, either primary school teacher, or middle school teacher, or the senior secondary school teachers, they have been given the work, the school, they have treated as on duty. It is not that you have not completed your syllabus for your classes, so that's why your ACR will be not good. It will be only fair. It is not that. So they have been governed by the ACRs. So school authority is not telling, no, you are not taught these students for the 3 months. That's why your academic taken into consideration, and it will not be taken as a good or good. It will be only a satisfactory. Can the
kindly see one thing? Suppose 1st January 5% joined. So one man is giving 50 lakhs, one man is giving 40 lakhs, one is 30, 120, 110. So how can we give 10 who is giving business 10 lakhs promoted? Forget about 60 days in election commission. If you cannot perform well, although joined in the same time, who is giving
then
50
you do one thing.
Yes,
you file the affidavit. I will decide this petition on affidavit, whether they are entitled or whether they are not.
Well, we have given already one affidavit as per Mala's
So
direction.
you will suffice this. So I will.
If Mala did it,
because this is
because
this will be affect the all over India.
Yes. Mala, they have given 3 examples.
Very cautiously we have to deal with.
They have given 3 examples in the last affidavit. We can deal that things in my affidavit.
Whatever it is, either you file the comprehensive affidavit.
Yes.
Affidavit in opposition, they will file, so that it has to be relied, because it will be in fact not only
all India effect.
It will all over India and future also. This has to be certified. Yes, Mr. Bhattacharya. Left. Though the respondent number 5 and 6 have filed their report and the petitioner has filed the exception, but after hearing the parties at length, this court is of the view a comprehensive affidavit in opposition is required to be filed by the insurance company to adjudicate the issue raised by the petitioner in the present writ application. Accordingly, the respondents are directed to file affidavit in opposition within 3 weeks. Within 3 weeks, reply within 2 weeks.
My lord, 1 week, 1 week.
Matter after 5 weeks.
My lord, only one thing, my lord. In the meantime, let them take no adverse action. And my lord, kindly fix it within the top 10 matters, my lord.
लिस्ट हो गए 5 अक्टूबर में कौन सा डेट हो गए?
80,000 or so. Well, a simple thing request, my lord, they should declare there should be no penal measure because of failure during this period.
But Mr. Bhattacharya, what stand they have taken, now the court has to take the burden on.
Give them that.
It has to be decided either way.
Sir, no adverse action in the meantime.
We are not against the
Sir, no adverse action.
Not
Yes,
against.
okay. Let the honorable court decide this matter. I am sure the honorable will take care of this.
If it is there, I am here. The court is here. Court is here, Mr.
Ah,
Bhattacharya.
give the bless me.
Yes. Call.
Pattern 178.
My lord,
Who is for the petitioner?
my lord, I am Mr. Sobhasati Chatterjee is leading this matter. Now he is leading another.
Which matter?
Huh?
Which matter?
This matter, my lord.
Huh?
This matter.
Which matter?
178.
Ah.
Mr. Sobhasati Chatterjee leading this matter is Sobhasati Chatterjee.
What is the matter about?
Photo ले लेते, photo ले लो.
What is the matter?
I didn't know.
ये अच्छे.
My lord, kindly not today, my lord.
Immovable property. How the writ is maintainable? ये तो main में जाने दो. This is not SIR.
Lordship,
This is not SIR. This is not SIR.
not SIR. This is related to the election commission.
Copy review होगा. Scanned copy.
179. These are all the same. Who is 179? ये क्या है?
नामिका पांडे.
ये
हो जाए.
ये भी नहीं है.
ये भी नहीं.
Delete. Delete. अरे यार. Yes, next.
80. 100.
क्या भाई यार नहीं है? एसीओ नहीं है? एसीओ कहाँ है? गांजा लेने गया?
Scanned copy. Scanned.
Delete. हाँ? ये सब फाइल हमको जरा शाम को बताएगा क्या है. ये भी नहीं. हेलो. नेक्स्ट.
182.
181.
182.
Yes. It is pending before the appellate authority. So I am praying.
Page number. What is the page number you appeal?
Page.
Yes.
Appeal page number.
Page number, my lord. Yes, yes. My lord, 28.
Disposed of.
Have a scanned copy.
Page 20.
Sure.
Yes, yes.
183.
My lord, 183, my lord, same.
183.
Same.
What is the page number?
My lord, my lord, my lord, page number, my lord. Yes. 25. 25.
Disposed of.
Scanned copy. देंगे.
Next.
Yes, my lord.
My lord, affidavit of service.
Page number.
Service লাগবে না। এখানে page number লেখা আছে। Page number পাঠাবেন।
Included, my lord.
Included.
Scanned copy টা পাঠাবেন।
Included.
Yes.
Yes, included. We have order. Na?
Included.
Disposed of. Yes. Next.
Well, I want to Lord, this is my appeal, my lord. The appellate authority, my lord. Appellate authority, my lord. Appeal is, my lord, at page, my lord. Page 76, my lord.
Disposed of.
My lord, this, my lord.
District.
In the meantime, not to give effect, my lord, to the, my lord, memo of the, my lord, food supply commission, my lord. Not to give food supply department, page 86. A memo has been issued, my lord, that who are in tribunal and who are in CA, page 86. The memo has been issued.
Who has issued?
My lord, the food supply department.
What?
That, my lord, last, my lord, bottom, my lord, where the beneficiary claims to have filed an appeal before the SIR tribunal or submitted an application under CAA, the area inspector shall obtain and upload and copy of the relevant appeal in the portal and mark the ration card to remain active. My lord, my appeal before the, my lord, appellate authority.
Same thing. SIR tribunal. They are giving benefits. Whoever has filed their appeal, no
Lord.
order is required. No interference is required.
Yes.
Disposed of.
All right. Madam.
A number is scanned copy পাঠাবেন.
Next.
27.
Disposed of.
40. Page number 40.
Disposed of.
Page number my lord.
Disposed of.
Lordship, page at 44.
Disposed of.
32. Page at 32.
Disposed of.
Page at 42.
Disposed of.
192. Others are there.
How many persons? Who is the petitioner? It is find that there are how many? Disposed of. No order. No order. Next.
Appeal is at page 39. Appeal is at page 39.
67. 67.
Of.
92.
Disposed of.
196.
31.
Petitioner, my lord, in this matter, the petitioner is a government teacher and he was the BLO also.
31.
That is, page 31 is my appeal.
Tell to the appellate authority. Yes, next.
My lord, will kindly consider it on an urgently basis, lordship.
Yes, next.
43 page.
Okay.
Page 31.
Stand copy. Stand copy. तुम्हारे
Page 31 again.
ये दोनों नहीं दे रहे 24.
Disposed of.
26.
Disposed of. Disposed of. Disposed of.
Page 28.
Disposed of.
वही है.
None appears dismissed.
Dismissed.
Next.
24. शुद्ध दिए दे.
24. 206 item is page 24.
24.
Disposed of.
32.
Page number 32, 207.
Disposed of.
108.
108, 29.
29.
207, page number 32. Page number 29.
Disposed of.
209, my lord, offline appeal, page number 41.
Disposed of.
Page
number 12, there is an urgency, my lord. I have to pull some of my.
Which one?
210, my lord.
Ah.
I have to pull some of my property for paying my son's engineering college fees. I have any documents of my college, of the engineering college of my.
Not counsel for the petitioner submitted the son of the petitioner is studying in engineering, pursuing the engineering degree or diploma.
Degree, my lord.
Pursuing the degree in engineering, but engineering, and the petitioner is required to pay the fee by selling his landed property, but due to the deletion of the name of the petitioner from the voter list, the authority is not allowing the petition to sell the landed property recorded in the name of the petitioner. The submit the petition has already prepared an appeal before the appellate tribunal for disposal of the appeal for inclusion of challenging the order of deletion of the name of the petitioner from the voter list. He prays for expeditious disposal of the appeal. In view of the submission made by the counsel for the petition and the circumstances mentioned above, the appellate tribunal is requested to dispose of the appeal as early as possible before the period of 3 weeks from the date of this. Yes.
Page number 32, my lord.
Disposed of.
Page number 40.
Disposed of.
13. Page number 26.
Disposed of.
Page number 28.
Disposed of.
Page number 27.
Disposed of.
6.
Disposed of.
22.
Disposed of.
Yes, my lord.
Yes, my lord.
Disposed of.
I'm a school teacher. What chance do I have? 76.
Disposed of.
Scanned copy. 32 page.
Disposed of.
220, my lord. This is my supplementary affidavit. Appeal, my lord, dismissed without hearing, my lord. Last occasion, your lordship called for a report.
Call for a report.
So call for a report. But they objected, my lord. For that reason, my lord, your lordship called for a report. Your lordship passed the usual order, but they annoyed, and thereafter, my lord,
No, annoyed.
Your lordship called for a report from them, my lord.
Where's the dismissal?
My lord,
Excluded. Only one appeal.
Yes, my lord.
The petitioner submitted. The petitioner had preferred an appeal against the deletion of the name of the petitioner from voter list. As the appellate authorities are not taking up the matter, the petitioner has prepared the present date application with the prayer for a direction upon the appellate tribunal for disposal of the appeal prepared by the petitioner as early as possible. Pendency of the writ application, the appellate tribunal has taken up the appeal filed by the petitioner without any notice to the petitioner and without giving any opportunity of hearing, which is a date. The appellate authority has excluded the name of the petitioner from the roll. On which date?
Excluded from
Counsel for the petitioner prays for a direction upon the appellate tribunal to restoration of the appeal and restoration of the appeal, and after giving an opportunity of hearing to the petitioner to dispose of the appeal as early as possible as early as possible. Consider the submission made by the counsel for the petitioner. The appellate tribunal is requested to restore the appeal of the petitioner being appeal number. Where is the appeal?
My lord, appeal, my lord.
7. Pin lagi chale kuch.
Which page your appeal?
7.
Page?
Page, my lord, 81st. Sorry, my lord.
Appeal number APS 2521G3103.
My lord, 97, my lord. Sorry, my lord. 1197.
7 as early as possible. Preferably within a period of 3 weeks. Restore both these. Yes, next.
221, my lord. My 220, husband of the 220, but unfortunately died in an accident.
Counsel for the petition submitted. The petitioner died in a road accident. Thus, the petition is become infectious.
Well.
Yes, next.
Page number 105, my lord, there is a urgency, my lord. The petitioner's name was blocked from the ration card. For that reason, she can't getting the social benefit. Also, she can't update her KYC. For that reason, she can't withdraw money from her bank. Also, my lord.
Then the counsel for the petitioner submit that the petitioner is not the due to the deletion of the name of the petitioner from the voter list, comma, the petitioner is not in a position to get the ration from the FPS shop, and this is also not in a position to 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 update the KYC in the bank. Due to which the petition is also not in a position to operate the bank account. She submit that being agreed with the deletion of the name of the petition from the voter list, comma, the petition already prepared an appeal before the appellate tribunal, and she prays for disposal of the appeal as early as possible. In view of the submission made by the counsel for the petitioner, the appellate tribunal is requested to dispose of the appeal preferred by the petitioner as early as possible, preferably within a period of 3 weeks from the date of this. Next.
23.
34.
Disposed of.
44.
45.
45.
Disposed of.
25.
Page number 35.
Disposed of.
23.
Page number 24.
Disposed of.
27.
Page number 52. Your Lordship.
Disposed of.
28.
Page number 48.
Disposed of.
29.
Page number
31.
Disposed of.
30.
Page number, Lordship, 57. The petitioner is a government school teacher, and also she is a polling officer in the last election, Lordship.
Informed to the appellate authority and disposing. Yes, next. 31.
24.
Disposed of.
32.
232, there is some urgency. Petitioner number 1 is a handicapped person and unemployed. He intended to sell his property, which was registered by a sale deed, and made a sale agreement for advance payment. Now the ADSR Boshirat is saying that your name is excluded from voter list, so you cannot sell your property.
Correct. So what do you want?
Petitioner, I just want a direction that I can sell my property and
Can't we? Unless and until you succeed in the appeal.
But my father and mother both are included in the voter list.
Huh?
My petitioner's father and mother both are included in the voter list.
Correct. Your name has been deleted.
My name has been.
So, but landed property is in your name, and
in the name of 3%. All
correct. Your name is also there,
Yes,
but
my
your name has been deleted.
My name
So how it can be? How you can sell the property, and how the part sale can be made? Disposal.
Kindly expedite the disposal.
Disposal.
I am for the state.
Yes.
Lordship, may I be permitted to mention, Lordship? My SIR matter was last heard on 20th of August, that is last Thursday, but the order has not been uploaded, my lord. For that,
What is the number?
Should I give
What is the writ petition number?
should I write it and hand?
Give the writ petition number to my
Lordship,
court.
kindly appreciate that. Petitioner.
Give the writ petition number, date, which date, and what is the writ number. We'll see to that.
I'm applying.
It is not possible to this court to correct the SIR order. What can be done? It cannot be. My officers, see, I have taken one extra room for the SIR briefs. Court number 26 is full of SIR matters.
Extra room?
Every day 600 matters is being filing.
Just for direction for expeditious disposal.
The courtroom. That's why once I disposed of, where it is going, we don't, neither my officers knows. Once I sign the order, we don't know where the file kept. There's no space for keeping the file.
Correction korbe ki kore?
How? If I will take also, that's what I'm telling. Every day I'm telling SIR matter not to mention for correction or not to mention the list. I have directed my officials, whatever they are getting the file, it will be listed accordingly.
ঠিক আছে অন্য মামলা
That will see. I will not assure whether the file will be located.
ঠিক আছে আমি জিপি
File will be located, I don't know. Every day 200, 300 matters get.
I understand. I told him lot that.
I appreciate it, but what can be done? Tell me, you are appearing for the state. So if give the number, if it will file be located, then we'll see to
দিয়ে দে যদি ফাইলটা লোকেট করা যায় একটু দেখুন না কি হবে একটা
if the file located, then it will
he will get his fees below.
Yes,
he can raise a bill then if his name is there. But I'm sorry to trouble your lordships. Why I'm troubling? Just have a look at it. Lord, this my lord extended the interim order on 24th July, kept the matter on 26th August at 2 p.m. 12 noon, and Lord extended the interim order till that time. Now, my lord, 26th is declared as a holiday. My lord, I want to do it now. My lord, I want to do the matter. Keeps it any day nearby, my lord, and my lord, extend the interim order on Thursday, Friday, whenever my lord's diary permit, or next week, any day. I want to do this, my lord, because I want to do the job. In the midst of something, we have come to court. Still, I can perform the project.
But we have filed one application for
Yes, that vacating
challenging the maintainability, my lord.
Yes,
This honorable court has no jurisdiction, my lord. So, my lord, in that matter, my lord, I'm filing my reply, my lord, against their affidavit in opposition.
No, by the last order, my lord also directed my learned friend to use affidavit against the writ petition.
No, my lord, since the maintainability under challenge, my lord, let the issue of the maintainability be decided first, then my lord will file.
We could have.
I will take the whole.
Yes, whole matter. You file the affidavit.
Because my lord, there is an issue of arbitration. It's a factual.
I will take accordingly. I will take
So, my lord, let me file my affidavit in reply, my lord, against their.
File
only my lord directed him to use the.
Any date of your lordship's convenience, my lord, will.
I don't think before October you will get any date.
I can understand.
Because it was fixed tomorrow, my lord.
Tomorrow at 12 noon it was fixed.
Kindly fix day after tomorrow.
Joseph, diary full, but any day, kindly.
Any day, next week. Then.
Just come मिलेगा. October.
Finish of the entire matter.
7th October.
Kindly keep me 7 days time.
12 noon. Before that, my diary.
7th October ওই 28টা মামলা ফিক্স করেছিলেন কি জজ স্যার? তো কবে করলেন? একদিন 12টায় করলেন?
7th October.
7th October ফাঁকা দেখে নিও। Yes, very good.
12 of like. फिक्स करेगा, जजमेंट कब पास करेगा? तुम अक्टूबर में फिक्स करेगा तो जजमेंट कब पास करेगा? तो मेरा छुट्टी जाने नहीं देगा।
But I want to, if September দেখো না একটু।
Won't take much time, but it's short matter.
The star has arrived now. 21st, 12 noon. Grateful to lordships. If in the meantime they complete the formalities of affidavit, the writ petition can be decided.
They file the reply.
No, they file the reply to the vacating application, not against the writ petition. If ultimately my lord holds it maintainable, then again another
You
affidavit.
not file the affidavit.
So you complete that in the meantime. With the prejudice.
Affidavit in opposition not
main application not filed.
So then again it will be delayed.
But then we'll file it by 7 days.
I am not taking in the piecemeal.
We'll do it within 7 days.
7 days.
Within 7 days.
The matter is listed as listed in the supplementary list. on the prayer made
এটা
by the
করতেই
council
হবে
for the petition for extension of
এটা
interim
করতেই হবে,
order.
আমার কিছু karaর নেই।
It is submitted that the matter is
করিনি, আমি
to be
পাগল লোক।
tomorrow at 12 noon, but due to
এই কিছু
the declaration of
অন্য
holiday,
20 তারিখ দেখো, 19 তারিখ দেখো,
holidays,
দেখো না
the
প্লিজ দেখো
petitioner
না।
mentioned the matter for
এই
extension of
মামলাটা
interim
মক্কেলটা
order.
পুরো পাগল একদম,
And
মাথা
he
খারাপ।
prays for fixing a short date so that the matter can be disposed of as early as possible. Learned Counsel for the respondents have filed an application being CAN 1 of 2026, challenging the maintainability of the present date application. The respondents have filed affidavit in reply to the applicant opposition in CAN 1 of 2026. Let the same be kept in the record. Let the matter appear on
But 21st, I have some difficulties, my lord.
8 September.
It could be 8 September, my lord. I'll be grateful to your lordship.
করে দেয় তাহলে ছোট এফিডেভিট করে দেয়।
8 and 21st, no.
No, 8 September at 12.
8 September at 12 noon.
Because my lord, I
September at 12 noon.
ভালো হবে না।
Yes. Interim order is extended till next date of the hearing.
my lord, grateful to your lordship.
Chakraborty is so busy. Very difficult to see an empty page in his diary. Unlike me, I don't have a diary.
Maintainability.
My lord, before my lord, my learned friend places this matter on merits, my lord. My lord, I have one predicament to place before your lordship, my lord. Kindly seize this. My lord, the primary respondent here is the Regulatory Commission, my lord. As on 5th of August, the entire commission's composition has changed. So, my lord, as far as the panel is concerned, there is no confirmation regarding, but I'm told that a decision will be taken in the course of this week.
Yes.
Well, I leave it to your lordship, my lord. He has informed me in all fairness. Only one thing, my lord, there's an interim order that we are enjoying. My lord, if it so commences to your lordship, my lord, it's a matter where, my lord, there's a penalty has been levied. My lord, inconclusive findings by the commission. If your lordship pleases, it can be remanded back if they can for fresh consideration.
Yes.
My lord, I personally called up the secretary to the commission, my lord. He also could not confirm regarding my appearance today. So, my lord, a decision will be taken in the course of this week, my lord. Since this is not a private person, my lord, this is a statutory commission, my lord, without any authorization.
Okay, I am fixing in the meantime. You see if they take decision, inform this court or mention the matter.
I'll do that.
Though the matter is specially fixed today at 2 p.m., but the learned counsel for the respondents has handed over the notification dated 5th August 2026, wherein the government has reconstituted the West Bengal Clinical Establishment Regulatory Commission. Accordingly, counsel for the petitioner prays for time to take instruction from the new Clinical Establishment Regulatory Commission, constituted on 5th of August 2026. In view of the above, the case is adjourned. Let the matter appear on up to 13th October at 2 p.m. 2 p.m. Interim order is extended till the next date of hearing or until further order, whichever is earlier.
Great. Great.
Next. Let me write.
My lord, I pray for a pass over. My learned counsel is.
Last time also the same thing. Nana person on behalf of the state, the petition came 10 matters.
State has, the state is about to file a report.
On the last occasion, I was on my legs when the matter was called on, and subsequently when I reached, the matter was over.
Yes. What is the matter?
I had to file a report.
The state has to file a report.
It is very sorrow state of affairs, my lord. Despite several communications through email and through telephone, they are not providing us the report.
Sir, the report has been provided to them thrice.
Report
Who
has been
provided?
Which
State
report?
House, state-
Oh, acha, state.
Stated
Sorry,
for the.
how you can.
sorry, sorry.
That's what I'm telling. The council is not.
My lord,
getting-
may I
You are appearing for whom?
I'm appearing for the 6th. I have filed a report.
Yes.
Now, may I draw your attention to paragraph 4
Paragraph 4
of the writ petition?
Yes.
My lord, in the paragraph 4, it is a clear admission that they worked till 2nd of August 2010.
Hmm.
Now, after that, the bank was not functioning. That is their own admission.
Hmm.
And the order of the Honorable Court is that they should be paid their wages in accordance with law. We have already paid the wages, everything, the respondent number 6, and that report has been filed.
Hmm.
Now, there is no pleading
Hmm.
in the whole writ petition that they even served for 1 day after 10th of August, 2nd of August. Now, when there was bank was closed, there was no work to offer. How they could have worked?
Sir, but no termination, no
That is
termination.
that is a very
There was-
different story altogether. But the bank stopped functioning.
There was
Where
no
is the question? There was no management, nothing.
There was no
Who
termination.
will give that
was
termination
given
notice and everything?
Because there was no termination, we
Who are
couldn't
you?
find a job.
Who are you?
I'm the respondent number 6, my lord.
Who are you?
There is a committee which was formed.
I am asking who are you?
I'm for the respondent number 6. Who are you? A committee, my lord. That committee has been formed. That is a party chairman of this one.
Why you are taking the sole responsibility?
I'm not taking
If the bank is not paying the amount, why you are taking this sole responsibility?
My lord,
let the bank come. Let the state come.
My lord, actually, I am just placing whatever has happened.
I remember what you have happened.
I've already placed everything by my report. I don't
They
want
are
to
the
take
bank employee.
Yes.
Bank is closed due to the cancellation or of the license. But the Reserve Bank of India has not taken decision with regard to the employee of the bank. The matter referred to the administration. Administration constituted a committee to consider with regard to the remuneration, with regard to the other thing. You have filed the report. What are the remuneration? What of the it has been paid? Some of the authority, some of the petitions are not received. Now they are telling that from they have not been terminated. What's their status? So you are telling that I am the committee. Whether what is the committee is only with regard to the with regard to the entitlement of the petitioner.
My lord, as per available records, the charge has been handed over to the assistant registrar corporate secretary Howrah Range.
Correct. So
now he is in
that's
charge
why-
of this.
That's why the court has called for the state response. What is the state response? Under whom the bank has been was working?
Bank was working, banking function was under the Reserve Bank of India.
Not
and
Reserve
they had
Bank of India,
administrated
the cooperative bank under which bank?
under the register.
Then the report is required. Let the register say.
But I am
You have
also
been made a committee and you are dealing with all the things. What you have done, you have disclosed that. Let the state come with the report whether they are the employee, they have been terminated, they have been entitled to get the payment. They have to decide. If they are entitled, then the committee will see. Yes, they are entitled. What the committee will do? You have to see what are the document who is entitled. You have done your work. That's all. So how you can say that they're not entitled to that?
No, I'm not saying it. They're not entitled. I'm just referring to their own status, what they have decided.
It is admitted fact. It is admitted fact. The bank was closed.
Bank
If the bank was closed, bank was closed. They have been. It is not that their appointment was illegal.
Admitted fact.
It is not that it was appointment was illegal. So what the authorities have taken, what the authority has taken the decision, what the chief secretary has taken the decision, what the registrar of cooperative has taken the decision with regard to the employee of the bank. There should be a decision from the authority. Bank has Reserve Bank has taken the decision for cancellation of the license. If the bank is not working, functioning with regard to the license, what about the employee? State is the guardian of the employee.
My lord, the whole litigation started, there was an order of liquidation. Now, once the bank is put under liquidation, the employment of every staff ceases. That is the law. I can
So if the liquidation, what order has been passed by the liquidator?
No, liquidator was never, there was a intervention by this honorable court and
No, that's what I'm telling. So if the liquidation is, the liquidator has to take steps. Whether they are entitled or not, the liquidation process has not been completed.
No.
In the meantime, matter came to the court.
Yes.
The division bench has passed an order to decide the entitlement.
Okay.
How soon you will file?
Like they are not responding.
Who is not
Necessary
responding?
Order may be passed. Several communications made.
This court find the learned advocate appearing for the
Kindly have a look.
For the state authorities submit that in spite of several correspondence made by the learned advocate to the state authorities, none is coming forward for giving any instruction to the learned advocate appearing for the state. In view of the above, the respondent number 2, the Registrar of Cooperative Society, West Bengal, New Secretariat Building, is directed to appear before this court in person and to explain why they are not in person on 8th of September 2026 at 10:30 am. Let the matter appear at the top for appearance of the respondent number 2. The department as well as the petitioner is directed to communicate this order to the respondent number 2 for compliance. That's ওইটা নেই Yes, next. इसको टॉप में रखना 8 तारीख को अपीयरेंस ऑफ द रजिस्टर
नेक्स्ट मैटर my lord.
और ये फाइल डिपार्टमेंट ने भेजना है एक्शन के लिए अपना पास बांध के यहाँ नहीं रख देना.
I am appearing on behalf of petitioner.
Yes, item number.
Next, item number 20, my lord. My lord, I am appearing for the Murshidabad Jila Parishad, my lord. My lord, there is a talk of settlement is going on. My landlord will not.
You are appearing for
Murshidabad Jila Parishad.
Yes, you are.
I am for the petitioner, Lord.
Yes,
talk of settlement is going on.
Settlement is going on. So dispose of.
Lordship, kindly fix the next date. Fix the matter.
You dispose of him, or I am sending it to the mediation. Go and settle the dispute before the mediation.
Kindly. Fix.
It is submitted by the land council for the parties that the settlement, the talk of settlement is still going on between the parties and prayed for adjournment. According to case adjourn, let the matter appear on 17th November.
I'm glad to lose.
Next.
21.
Lordship, I am for Durgapur Municipal Corporation led by Mr. Sandipan Banerjee.
That matter will be very
Lord, I am for the Assessor Durgapur Development.
May I recap small
You are appearing for?
For the state, fund number 1 and 3 Millard. Yeah, Millard, land was leased out to the company, which was subsequently there was a share purchase agreement and joint venture through which the petition came into the picture. Share capital reduced, paid up share capital, and thereafter the amount was paid, supposed to be paid to the respondent number 4 and 5. There were several allegations in the petition which have been leveled. I had granted leave to file report. We have filed respondent number 2, have filed report. Respondent number 4 being the Asansol and
Durgapur Development
Authority has filed a report. To which, without my report, there has been 2 exceptions taken out. One is the original, and thereafter I have given them leave to deal with paragraph 9 of my exception report and file an additional exceptional report. Now, in the additional, they have at least narrated 70 paragraphs, to which I have been briefed. I think a reply has to be filed to that.
Reply of?
Reply to the
exception.
Yes.
Filed by the petitioner.
By the petitioner to my report, which was only subject to the leave was granted with regard to the reading of paragraph 9 of my report. Now they have redealt it, and now in their report, in the subsequent report, they say we have nothing to do with the petition number 1, 2, and 3. This is between me and the respondent authorities number 4 and 5. Asansol Development. Initially, the petition has been filed against me, claiming prayer against me, respondent number 2. So now we are. This is what I wanted to give to your lordship's knowledge and leave it to your lordship.
Well, what needs to be brought to your lordship notice is the stand of the present government is what the matter was last time adjourned post that this is for it's an industrial policy of the government. This was a government company. So basically this is for setting up a life-saving drug unit in Durgapur in the land which is owned by the state. Now, I have stepped into the shoes of the state in view of the joint venture and 100% shareholding being transferred in my favor. Do they really want the industry or not? Then otherwise we'll go into the matter. So it was adjourned. They did on the last occasion. They did not have appropriate instructions. Are they going to allow the unit to be set up at Durgapur?
Additional exception report.
No,
This needs to be
no,
clear. And
no,
as far as Mr. Bose's contention is whether the industry we want to or we
Yes,
we
yes.
don't want to, they're expired. The lease has expired. At the fag end, they have come up saying that respondent number 4 and 5 has not cooperated, not provided. There are ample submissions made in the report of respondent number 2, to which they had to file 2 times the exceptional report.
Again,
They want to file reply, otherwise this application will need that reply, and even if starts this hearing today, reply is 1 minute. I think this.
What is your stand? What is the stand of the state as on date?
They are in report number 2.
What is your stand? That's what I'm telling. Whether you are carrying the earlier report, you are carrying the stand taken in the earlier report,
I am carrying.
or the present government will wanted to see whether it can be facilitated.
This has been shifted. What is being submitted from the state to the Asansol Development and
No, that's correct. That's correct.
But I do not have a copy of the exception, so I do not know what the contents of the exception are because that was in respect
No,
of
that's
the report
correct.
of the state.
The problem is that the main dispute is that he wanted already there is an order only wanted to shift and establish. If the government give the consent and they will cooperate, then the petitioner will establish that. Correct. Now, whether the government is going to support the petitioner or not support the petitioner, they are not going to support the petitioner, then the court has to hear the matter.
Correct. It's as simple as that.
This is on.
It is the lease of the state given to the state. It's a 100% state owned company.
Yep, if you're not ready,
before it is decided on merits, as far as I can assist your lordship by going all through the papers, as far as the reports are concerned and the exceptions taken.
No, that's why I'm telling Mr. Tiwari.
Consent and cooperating with the petitions, I do not find in the records. So, the reply is necessitated. Kindly give me 2 weeks time so that I can come back with.
I will give. That's why first the state come with the proper advice whether the state is ready to provide all accommodation to the petitioner what the petitioner wants. If they're telling that there is no required, you come with the suggestion.
Now petitioners themselves are saying they don't want any assistance from me. They're asking from the respondent number 4 and 5.
But I do not have a copy of the exception.
We have not any copy of exception.
Well, this is the difficulty. Well, Mr. Tiwari must understand this writ petition is not an adversarial litigation. This is for the benefit of the public of the state of West Bengal at large. If today industry is set up,
no, that's why I'm asking.
So is it your
that's why Tiwari, and that's why I'm asking you if you want that you have an instruction from the state authority that yes, no, we are not the writ petition is to be decided by the court, then naturally the court has to hear.
Absolutely.
If you take instruction, yes, the state is going to provide all the facilities what the petitioner intending to with the consent of the so that can be.
With regard to that, we will take instructions as well.
And Mr. Tiwari can be informed, my lord. Possibly he's not read, or possibly he's not been instructed. This is the only in the state of West Bengal, the only life-saving drug unit. There is only life-saving drug unit in the state of West Bengal. 70% has already been shifted to Gujarat because of the.
Maybe it is a life-saving drugs. But the conduct of the petition is also
Abar
the adjudication, my lord.
So that's why I'm telling, whether,
Clearances have not been given up. That has to be brought
so
before
which exception you wanted to file, which report?
Supplementary
Which
exception
report?
filed by them, which has been taken on report.
Of the exception of which?
Order dated 8th of June, my lord.
Exception of which report?
Exception to my, my lord.
Respondent number.
Respondent number 2.
Exception dated 5th of May 2023.
To the report of the respondent number 2.
Supplementary report in the form of affidavit of respondent 4 and 5.
Yes. Not 4 and 5, my lord. 2,
Report
2.
from the affidavit respondent number 2.
Yes, my lord. To
Yes.
this, your lordship gave us leave to deal with a certain paragraph, so we've dealt with it. Very well, very well.
So you have given the exception to that report. So Mr. Bose, you have submitted the.
Yes, I have.
That is the dated 24th February 26.
Yes.
Yes.
So you want to file the reply to this?
I want to file reply, my lord. My exception, they have filed exception to my report on 24th of February.
Me.
That's what I'm telling. 24th.
Subsequently,
No, my lord, correct. He is right.
supplementary exception.
Which is 5th May. So he wants to file a reply to my 5th May supplementary exception. Correct.
Paragraph 9. He has, my lord, intentionally all the paragraphs re-agitating the issue and closing my rights. That they are barred from stating this. My lord has not found. And this report was taken on record by order dated 8th of June, my lord. These reports that supplementary exception they have taken on record.
Has it been given on record? The George Saber কাছে নেই বলতে কোনো
Report.
Where is that thick one? এটা কোথায়? আর একটা এরকম মোটা আছে দেখুন। এটা আছে?
Have you filed?
Yes, my lord. It is as thick as this, my lord.
Thick?
Yes. This is the size.
Yes.
Yes. He wants to file a reply to this. He wants to file a reply to this.
This was only with regard to paragraph 9. This is why, my lord, I have indicated at the instance that
Okay.
That I want to reply.
How soon you file the reply to this?
May I take your lordship kind leave, my lord?
This is paragraph 9.
Yeah. Then counsel appearing for the respondent number 2 and
1 and 2.
1 and 2.
1, 2 and 3.
Right.
Now I am happy.
1, 2 and 3. Press for time to file reply to the exception filed by the petitioner to the report to the supplementary exception. क्या बोला? File reply to the supplementary exception filed by the petitioner to the report filed by the respondent number 2. Filed by the respondent number 2. Let reply be filed within 2 weeks after serving the copy to the land counsel for the petitioner.
But I also find that there are allegations against respondent number 3 and 4 as well.
Yes.
But I may be also allowed to file a reply.
With the supplementary.
All respondents 1 and 2. No. Respondents press for time to file affidavit in reply to the supplementary affidavit to the exception filed by the petitioner to the exception filed by the respondent. Let reply be filed within 2 weeks after serving the copy to the land counsel for the petitioner. List the matter on 29th September under the same heading. Yes.
May it retain its position or only indulgence sanction.
Yes, under the same heading. 29th September. Next.
These are the.
Yeah. Next. Rather not today. बाकी ठीक कर दो. Next.
In 23, my lord, I am appearing on behalf of the respondent number 4 and 5, my lord.
I appear for the state respondent.
23, I am the petitioner, my lord.
Yes.
May I file my report? Lordship, may I indicate? Lordship,
You are appearing for whom? Yes.
state response.
Yes.
Lordship, report, Lordship will take page 3 of the report. It says that it's a private dispute between the mother and the daughter. So the writ petitioner is the daughter. She's filed a writ against her mother saying that she doesn't have access to her father. Report says that Your Lordship, the father has denied these allegations when police authorities inquire. Father has denied the allegations of the petitioner. Your Lordship, may I indicate in the writ petition they have annexed a copy of the order passed by Justice Shubhra Ghosh, where they have filed a writ on the same cause of action that writ was dismissed, holding that it's a private dispute. The writ court will not interfere. These are my humble.
My lord, before entering into the merits, my lord,
P10,
read in
I have
filed-
annexed already. It was a read done for police protection. The order I have annexed in running page
Why before
53,
this court?
54.
Yes, my lord, but he is filed in the wrong determination, my lord.
Why
This is
before
against-
this court? Police
Because,
protection?
my lord, I'm in this court because I can't meet my father. I'm coming
Correct.
from all
You go
the
to
way
the
from
court,
New
the
Jersey, my
other
lord.
court. This court can
Yes, my
Those
lord.
are not
This is my only submission because relief was
my lord,
paid
this
against-
is those are not a court to give me a justice within the short period of time. He may be live today, he may not be live
the
tomorrow.
court to give the justices in the short in the
My
short
lord,
period.
a trial court is not efficacious determination for me.
This is a civil court.
No, my lord.
Ah.
Just need a right. The person should have the right to live with dignity, my lord.
Correct. Every person, every citizen
I
of
have
India have a
evidence, my lord.
dignity.
I have a lot of evidence, a lot of video recordings where the person is saying, that is the father of the petitioner is saying, he wants to be with her daughter. He wants to meet her daughter, his daughter. He's willing to see his daughter, and daughter has done no wrong. I have the pen drive consisting of several videos, my lord.
So why, how the writ
And my
court
lord,
can
I have also
interfere?
annexed a report of the doctor, psychologist, where she is saying that the respondent number 4 is suffering from a mental issue and she needs an immediate care.
Who?
The respondent number 4, the mother of the petitioner, my lord. I am ready. I have done everything till June, my lord. Till June, it was okay. I'm done. Treatment of my father, mother, knee replacement, everything she has done. She is a VP of a foreign bank, my lord. She's coming down repeatedly, can't see his father. And at last, all CCTV connections were disconnected. Even the caregivers were terminated. He is not getting a treatment, and then he has to go to the ICU with pneumonia at this stage, at the age of 89, my lord.
Earlier also the same thing, your writ petition was dismissed.
Yes.
Yes, my lord, that is because of private dispute. But, my lord, the person has the right to stay with the dignity, my lord.
Here, what is the dispute?
There, we requested the court for a police protection because we need to enter into the house, my lord.
Separate determination.
Somehow, my father's intervention, we were able to go for one day, and then the mother behaved, and my OP, respondent 4 and 5, my lord.
Court is not having determination, madam. I am releasing the matter.
My lord, if this case is released, I would, no other efficacious remedy is there for my lord. My lord, I have to go back for my job, and a trial court is not an efficacious remedy for me, my lord. Let me see my father, my lord. My lord, it's an extraordinary jurisdiction. Supreme Court, I have also I can cite the Supreme Court guideline over here, my lord. I'm just citing the judgments here, where the Supreme Court is repeatedly saying the writ courts has a jurisdiction, my lord. Here is a judgment of Oshini Kumar, as well another is JK Traders. And the third one I'm citing here.
My lord, apart from this, already my one writ petition is pending for police protection against.
Who are you?
I am for the respondent number 4 and 5. I am the mother and maternal aunt, my lord, of the petitioner.
Just filed after my case was disposed.
Let her finish, my
Just let me finish. This case was filed just after my case was disposed of with a remark that it's a private dispute, my lord. It was never moved in any court till date, my lord. It was filed in 2025.
For police protection against the petitioner here in, my lord, against the daughter, because the daughter that is pending, my lord, because my daughter has confined us by CCTV and her employed persons, NGOs. So we seek for police protection. One thing, my lord, apart from all these things, my lord, I being the mother, I do not have any objection if my daughter visits myself and my husband. but she cannot reside with her or stay with her because my husband is a Parkinson's patient of 91 years old, my lord. Second, my lord, he has some memory issues. My daughter lives in abroad, my lord. So contamination is a major issue, my lord. So she absolutely can visit her father, my lord. But she can't stay with us because already there is this existing dispute.
My lord, just 1 minute. This CCTV camera was installed in 2021, my lord.
What is that case number, repetition number?
My lord, WPA 29630.
And yesterday we have got the copy of it.
Of 2025.
25?
25.
My lord, the CCTV camera has been installed in 2021.
Petitioner has filed the present writ application praying for a direction upon the police authorities to allow the petitioner to assess the visit of her father and to stay in her father's house. This court find that police counsel appearing for the private respondent submit. The private respondents also filed a writ application being WP number 29630 of 2025, which is pending before the appropriate court having determination. This court, after going to the
I will
this
go
court
back
find
to
that this court is
leadership,
not
Lord.
having the determination accordingly. The WPA number 9050 of 2026 is released from the list of this court with the liberty to the petitioner to mention before the appropriate court having determination. Next. उसमें ऊपर लिखो report filed by the state respondent be kept with the record.
Yes. My lord,
yes.
When I moved these applications, my lord was kind enough. After going through, I'm asking the respondent to file a report. My lord, after going to the report prima facie, I was a little bit upset. And my lord said, very well, if you want to file a rejoinder, file it. Now, subsequently, I found that really my position is not so bad. My lord, this exception, I've served him. My lord, fortunately, I've got the assistance of my friend. He was in judicial service, so it's a good experience. Kindly travel to fast his report. Report very cryptic but very details. Now, paragraph 2, pursuant to the aforesaid, have you got it?
Yes, sir.
That is my affidavit.
Your exception.
And before that, their report.
Yes.
Their report is very material. Yes. May I praise my lord?
Yes.
Pursuant to the aforesaid order, the petitioner representations dated such and such were carefully examined by the competent authorities with reference to the provision of such and such, letter such and such, the contemporaneous departmental records, and the previous correspondence exchange between the parties, which clearly demonstrate that considering the extreme vulnerability of the site and related public interest involved, repeated requests and communications were made from the respondent authorities to execute the formal contract agreement and proceed with the work. But despite such requests, petitioners repeatedly failed and refused to perform their job contractual obligation. Instead, the petitioner repeatedly sought cancellation of the letter of acceptance and money unless money, additional promotions. Then, as such, initiation of penal action was duly conveyed to the petitioners and subsequently so-called notice allowing time period of 72 hours, very relevant. In my reply, I explained, was issued stating in details proposed penal actions. Due to non-submission of any reply within stipulated time period, letter was issued ICICI Bank for invocation of bank guarantee, which was duly remitted such and such. The proposal of the petitioner Tele Sanchez was not an unconditional proposal to execute the work in accordance with the accepted tender condition. On the contrary, the proposal sought execution of the work subject to several phrase conditions, including conditional timeline linking commencement of the post-monsoon period or till availability of the sand from Goekali, Purva Mendapur or other sources. Refund of the solicited bank guarantee amount, the subsequent publications of a fresh bank guarantee, finalization of terms and conditions de novo, reconsideration of royalty, etc.,
which are found to be contrary to the provision of such and such person. After initiation of penal actions by the forwarding bank guarantee and due remittance of the amount to the Bank of West Bengal, consideration proposal as submitted by the petitioner is an unprecedented request as per available record and such. Kindly take trouble to my. In the above stated facts and circumstances, I pray before your lordship to grant some time. Well, this is very last line is very important. Can you mark 1 second? In the above stated facts and circumstances, I pray before your lordship to grant some time for finalization of the decisions. I don't know what remains because it is a decision and you already take it in now. Now kindly come to my, I'm sorry, exception. এটা তোমার রিপোর্টটা পড়ে দিলাম কপি নেই আমি তো আমাকে একটা কপি দিয়েছিস কপি আছে আর আচ্ছা আচ্ছা আমি দিচ্ছি যা আমার ফেরত দিবে কিন্তু he has got no copy. Then my lord, paragraph 2. I state that the report that is stated to have been signed on resolution 127 in terms of the order of the concerned state. Advocate group A, learned scholar. Then I have gone through both the covering letters and the report, both dated July 23, 2026, and understood the meaning of the person. At the outset, I state that the report such can be segregated into 2 parts for the sake of convenience for appropriately traversing the same by the petitioner. The first part deals with the facts and events prior to July 3rd, 2026, and the second part deals with the facts and events post July 2026. First part. In the first part, the respondent has clearly alleged the petitioner repeatedly failed to execute the formal contract agreement and proceed with the work. The petitioner repeatedly failed and refused to perform their contractual obligation. The petitioner sought cancellation, the letter of acceptance, award, and contract answers upon unless money performance the bank guarantee. The petitioner was subsequently served with a so-called notice allowing a time of 72 hours. And next, due to non-submissions of any reply within the stipulated time period, letter was issued by the bank, and this is the crux of their objection. I did not suppress anything. I know what is that, and I'm ready to willing that to face. Kindly then, the aforesaid allegations are without any details, particulars, or dates, and as such, the same are vague and evasive. On this score alone, the report deserves to be discarded. Without prejudice to apportion, the petitioner specifies response as follows. With regard to the allegation as the paragraph 5I above, the petitioner denies and disputes the allegation inasmuch as the letter of acceptance was issued by the Chief Engineer, South, National 2 on June 17, 2025, the portion, whereas admittedly the formal contract papers were handed over to the petitioner on November 19, 2025. Very relevant. Page 37 of the petition. Such formal contract papers were issued to the petitioner after the expiry of the unfortunate days from the date of issuance of the letter of acceptance, which was after the expiry of the bill validity period 120 days. Right from the beginning is always irregularities. Now they are blaming me. There is no explanation in the report as to why the formal contract document was not handed over to the petitioner within the bid validity period, as such the allegation is baseless and frivolous. With regard to the allegation at page 522, have the petitioners denied and dispute that it had repeatedly failed and refused to perform its contractual obligation immediately after receipt of the letter of acceptance on June 17, 2025. The petitioner submitted a bank guarantee to the tune of 87,30,000 June 2007 within 3 days from the date of issuance of the letter of acceptance towards performance security, which was invoked admitted on May 29, 2026, page 143 of the petition, and guaranteed sum was remitted on May 30, 2026, page 100%. The petitioner could not proceed to commence and execute the work since the respondent did not enter into the formal contract agreement, which is the basic and fundamental things, my lord. There must be a contract agreement, an essential condition precedent, which was to be performed in sequence of the activities as such the allegation is baseless and frivolous. Then, with regard to allegation at page 37, the petitioner states the petitioner was compelled to seek cancellation of the letter of acceptance, refund of earnest money deposit, and additional performance security since the respondent did not allow the petitioner to proceed with the execution of the work by signing and executing the contract agreement despite submission to the performance security 87 lakh 30,000 by the petitioner immediately on receipt of the letter of acceptance. Immediately I deposit the money, my lord. Within 3 days, the petitioner request was bona fide and legitimate and based on genuine reasons. The respondents are not entitled to depend their inaction or wrong action, and their allegation in this regard is not substantial both of the facts of law. If I am a so bad man, I will not deposit such a huge amount of money within 3 days. Then next, with regard to the allegation as in paragraph 5.4 above, the petitioner admits that the so-called notice was served upon such and such, with requiring the petitioner to furnish his response within 72 hours. My lord, very important, very relevant. The petitioner furnished his response May 29, 2026. The respondent served the so-called notice after expiry of 11 months. Kindly see, my lord, so-called notice after expiry 11 months, very relevant. From the date of issuance of letter of acceptance on June 17, 25, after 120 days of the bid validity period and days of contractual completion date, without first terminating the contract, if at all such contract was existence. The petitioner's second condition is that the respondent had made adroit attempt to count 72 hours meticulously on time and date, but had conveniently ignored the fact that while the so-called notice was issued on May 26, 2023, the state government had declared holiday on May 28, 2026. According to the Jail Codes Act, my lord, date cannot be taken into consideration in computing that period, that particular period. May 26. Therefore, ostensibly, this holiday ought to have been excluded from the time of 72 hours. The allegation of the respondent, therefore, is contrary to fact and not such. So, if my objection immediately after that date, that means if the date is excluded, I am now within time, and that should be excluded as per Jail Codes Act, the holiday. With regard to the respondent allegation that due to non-submission of any reply within this stipulated time period, letter was issued to invocation of bank guarantee, which was duly remitted by the bank to the revenue head of the Government of West Bengal. The petitioner states that for the reasons stated paragraph such above, the respondent was not entitled to issue any such invocation notice on the same day. That is, the same day invocation notice is a so fast story. Moreover, there was no urgency to invoke the bank guarantee within few minutes, as alleged by the respondent, since the claim expiry date of the bank guarantee was till August 31, 2026.
Yes.
Why you are so anxious? I don't understand. And the respondent would have been well within his right to invoke the bank guarantee anytime on or before 31, 2026. In fact, from the conduct of the respondent, it is very much clear and apparent that the respondent had already decided to unduly and illegally penalize the petitioner and invoke the bank guarantee, for which the invocation letter was certainly kept ready. The act and conduct of the respondent, being the public authority, was not in consonance with the duties and responsibility of the second part. In the second part of the report, this one 6, it clearly has alleged that the proposal of the petitioner dated 3rd July 2026 was not an unconditional proposal, and on the contrary, the proposal sought execution of the work subject to several phrase conditions, including conditional timeline, a linking condition of post-monsoon period, or the availability of sand from the Geokali and other sources, as well as refund of the bank guarantee, amount the subsequent submission of fresh bank guarantee, violation of the terms and conditions de novo, and reconsideration of the royalty issue, which was contrary to the provision of NIT which was uploaded by the petitioner. Suppose, my lord, if it is not done, what will be the consequence, my lord? If I cannot complete that, again you will take that plea. And I cannot complete because until unless I recover that.
Next.
It is noteworthy that the response 6 has conveniently omitted to place on record that after finding its facts and conduct being wrongful and illegal, and after filing of the present petition, the respondent had issued a memo inviting the petitioner for a meeting. So not but on my own, I was invited. Who asked you to invite me? No problem. But you knowing fully that you have committed wrong. Memo for a meeting or supplementary evidence. And pursuant to the discussion and advice of the respondent. The petitioner had issued a letter, such and such. It is obvious and not expected that the petitioner would execute the contract under the same terms and conditions after expiry of 11 months from the date of issuance of the letter of acceptance, dated June 17. Accordingly, the petitioner had issued the letter on such and such date, where the conditions put forth by it were all legitimate and based on genuine causes and grounds. The respondent, however, did not rely to the said letter of the reply to the said letter of the petitioner, ostensibly for the reason that it had no valid reason to ignore or counter the conditions set forth in the letter of the petitioner. Most importantly, it has been very genuinely contention of the petitioner that the issue of royalty ought to have been sorted out first, inasmuch as the liability or obligation for payment of royalty is on the lessee and not on the contractor who procures or buys sand or earth from such lessee as per the exact component. But this is very interesting, my lord. Which they cannot do, they are asking me to do that. But the lessee is liable to pay that royalty. I am not. So no, he'll have to pay. Rules and statutory provisions related thereto. Along with this letter, the petitioner had extended copies of all the relevant rules and notification to justify substantiate the payment of the contractor. Also noteworthy, the petitioner had rightly requested for fixing additional timeline for completion of the work, since the timeline of 2140 days fixed tender has already expired. So naturally, I will have to ask that your original time is expired. In any event, the Source 6 was at liberty to discuss with the petitioner for finalization of the condition put forth by the petitioner. His letter as advised itself, no petitioner in the meeting. In the penultimate paragraph of the report, the Source 6 has merely opined that the proposal submitted by the petitioner is an unprecedented request and require opinion approval of the competent authorities of the government of West Bengal, which requires time for interdepartmental coordination. While the meeting with the petitioner was held on Thursday, and the petitioner submitted his proposal also on the same day, no explanation has been given in the report as to why the issue was not taken up on prior basis with the competent authority. He could have sent it earlier. There is no suppression. I've said everything. Everything is open. I state that for the reason mentioned here above, the purported report is answered and filed by the Resource 6 of the is vague and evasive, apart from the same containing false and frivolous input data. And
yes,
I further say results.
Yes, Mr. Banerjee. So what you say?
So, my lord, on that basis, finally take trouble to see whether at all the way they have proceeded is correct or not. The order which is passed subject to approval, that means they are not sure. The last line is very interesting.
Yes, why last line of your report?
Something
if you have
funny.
taken the decision, then above stated fact and circumstance, I pray before your lordship to grant some time for finalization of the decision.
How's it?
Your
that decision they have given. আপনার হয়ে গেছে
আচ্ছা তোমায় জিজ্ঞেস করছি
ইয়েস না আপনি মধ্যখানে বললে মুশকিল হবে similar rightly or wrongly my lord, two exceptions have been submitted before this honorable court and we should not exceed the brief within the brief. Now today definitely my senior learned brother will point out many defects of the respondents. We will also come out with many defects that has given rise to this situation. And the question is humanitarian. Why? Because the bank is so precariously damaged that you kindly have a look to the photographs that it does not require the quarrel between the parties in the court of law. Nothing, no affidavit. It is a decision-making process. The last line you have already shown. So the last annexures, Lordship kindly see, the people, the river has overflown.
Everywhere.
The people are homeless. We are fighting in the court. And my lord, the question is, we are pointing out the defects of one to the other. The fact remains, my lord, the basic issue is one, that the authority has utilized the bank guarantee and that he wants refund back. So, my lord, in the exception in the very second paragraph, we have already taken it before this honorable court. And we pray also to file affidavit in opposition to the writ petition. But Lordship, kindly come to the result of, on behalf of the respondent number 1 and 7 report. Pursuant to the aforesaid order, the petitioner's representation dated 1/7/26.
Where from you are reading?
My lord, the report that we have filed. The second paragraph.
Yes.
Pursuant to the aforesaid order, the petitioner's representation dated 1/7/26 and 3/7/26 were carefully examined by the competent authorities with reference to the provisions of ENIT, the letter of acceptance, the award contract, West Bengal, form number such and such. The contemporaneous departmental records and the previous correspondence exchange between the parties, which clearly demonstrate that considering the extreme vulnerability of the site and related public interest involved, repeated requests and this is important. Repeated requests and communications were made from the respondent authorities to execute the formal contract agreement and proceed with the work. But despite such requests, petitioners repeatedly failed and refused to perform their contractual obligations. Instead, the petitioners repeatedly sought cancellation of the letter of acceptance. It is the petitioner who sought cancellation of the letter of acceptance, award of contract, work order, refund of the earnest money. So, my lord, the petitioner has put the entire issue on the government, and now government is in a tight hand. Neither they can float any tender because the matter is pending before your lordship, nor they can come in aid with these helpless people who are suffering because of this overflow of the Hooghly River. So now this question has arisen. Now my learned friend can point out thousands of reasons. But what will be the status of the persons who are suffering?
No.
Now the question is that will not take away his right. I am not saying that. That I will file affidavit in opposition because he's
after the report.
After this report, because there are many other factors that have to be, because a report is not very, very short form of our submission.
My lord,
why I am saying so?
Short report. My lord never ever said come with short report. He could have explained everything.
My lord, the question is, my lord, that there are two aspects. One is his bank guarantee, and the other one is his cancellation. Cancellation is he has volunteered for cancellation, and the other part is bank guarantee. These are the two issues. So, my lord, on the question of, since he has volunteered the contract.
If you have taken the volunteers of the petitions, then why you have revoked the bank guarantee?
No. What I am
and invited me to
why I am trying to because this bank guarantee was at that material point of time when this thing occurred, my lord, repeated requests were made. But since he failed, that's why, my lord, the revocation of bank guarantee was made. My lord, rightly or wrongly, that will be decided by your lordship. My lord, I am not entering into that. The question is the other part. The other part is the floating of tender to safeguard the local people from the overflow of the Hooghly River. So, my lord, that's why, my lord, I am saying that on the question of revocation of bank guarantee, my lord, let me file our points, my lord, lordship. Give a short date. We will file our opposition. And on the question, let them file the reply. In the meantime, I will beseech your lordship, my lord, that let there be a fresh tender. Let them also participate in that tender. I am not, but to safeguard the people at large, instead of arguing the matter before the honorable court and allowing them to suffer. It is not that, my lord. I am from a different angle. I am submitting, my lord. It is not that I am submitting that we are all correct and he is all wrong. It is not that. Question is there may be certain defects in our part, certain defects in their part.
So as per your submission, let the writ petition be kept pending with regard to the revocation will be
Yes,
decided
yes,
subsequently,
yes.
and you will go for the fresh tender, and the petitioner will be at liberty to participate in the said tender, and you will not take any adverse reference against the petitioner
No,
with
no.
regard to
Yes,
the
yes,
cancellation
yes.
of the tender.
This is my
a
submission.
submission.
This is it. This much I can say for the interest of the people at large who are suffering.
My lord, he has already swallowed one course without any fault on my part.
No, that's why, Mr. Miller, it's a fair deal. Fair deal with regard to your revocation, because you have suffered the revocation. Correct. That will be decided. Let the float the tender, you participate, I will record his submission that they will not take any adverse reference against you
yes.
with regard to the cancellation of the tender.
Very reasonable order. I cannot say it is not reasonable. Very reasonable. But question is this, my lord.
Not order. The submission is
Ultimately,
one
order
re-
will,
and one rejoinder.
order will prevail over everything. But very one thing, one thing, one
This
thing.
submission I have learned
The
from
way,
him only.
no, আমার থেকে কিছু শেখোনি. You have not learned anything.
I have learned from him only that how to synchronize the entire issue in a small sphere.
Well, one thing is very clear that well, the way bank guarantees in cash is totally illegal.
So that will be decided.
The difficulty is well, once I want to participate, where I'll get the money? Already as I'm suffering.
Because
only personal
issue. The court cannot restrain with regard to the tender. This is a public interest.
Very well, my lord. I'm not standing in the way. Kindly appreciate one aspect. So naturally. So very well. This time I'll not until it is decided. This time they can't ask me for the further furnishing bank guarantee because that is in their hand. Enter money in their hand.
No, that will be decided. See, if you succeed in the writ petition,
Yes.
automatically will get.
No, that is always there, my lord. That is always there.
And you can manage. You are the contractor. You can manage it. Yes. You take instruction. I am keeping on Thursday. Mr.
No, it's all right, my lord.
Keep come on, ma'am. You take.
I'm being one minute. No? What do you mean? Very well, my lord. What is followed by lordship, my lord? Yes, agreed.
Yes. I am getting.
The petitioner has filed the present application challenging.
তোমার কথা শুনবো
Challenging the order of cancellation as well as the revocation of the bank guarantee. The respondents have filed report and the petitioner has taken out an exception to the settlement. At the time of hearing of the present application, the counsel for the respondent submit that due to the pendency of the present writ application, the respondent authorities.
Since they are asking for time, kindly fix the time and preemptively let it appear at some time.
All right. No problem.
The
We will file it.
Land Council appearing for the respondent authority submit that due to the pendency of the present writ application, it is not possible for the respondent authorities to proceed with the fresh tender for execution of the work. And the said work is on the public interest. Accordingly, he on instruction, according London advocate appearing for the state authority on instruction submits that the respondent authorities may be allowed to go for the fresh tender process, wherein the petitioner will also be entitled to participate in the said tender, and the respondent authorities will not take any adverse reference against the petitioner while deciding the tender process with regard to the cancellation and revocation of the earlier tender. We further submitted with regard to the revocation of the bank guarantee, the petition should be decided by this court after exchange of affidavit. In view of the submission made by the counsel for the petition, this court and counsel for the state, this court find that the counsel for the respondent has come with the has made a fair submission. Accordingly, the respondent authorities are given liberty to call for a fresh tender, wherein the petitioner will also have liberty to participate in the said tender, and the respondent authority will not take any adverse reference against the petitioner with regard to the cancellation and revocation of the fresh tender. As regard the as regard the revocation of the bank guarantee, respondent officer director to file affidavit in opposition by
By 4 weeks.
4 weeks.
3 weeks.
3 weeks.
3 weeks.
We'll
1 week.
2 weeks.
1 week.
One.
All right, 2 weeks.
All right.
Honorable my lord.
All
2
right.
weeks.
Within 2 weeks. Within 2 weeks. List the matter on 12th November. 12th November at 2 p.m. as specially fixed, madam.
I'm grateful. Develop. May I leave my lord?
Thank you.
I'm grateful.
Before your lordship takes up appellate side, the original side, there's a month list item 128 interim order is expiring tomorrow, my lord.
Tomorrow.
I'm mentioning upon notice. This is the last order, my lord. This is the mentioning notice.
Item number
128 of monthly list.
monthly list. The matter
Mr.
item number
Mr. Noti is
128
reading
of
in
monthly
respect of
list.
respondent, my lord.
But due to paucity of time, the matter could not be taken up hearing. Learned counsel for the petition has mentioned the interim order is till 26th of August 2026 and prayed for an extension of interim order. In view of the submission made by the counsel for the petition, interim order is extended till 30th of September 2026 or until further order whichever is earlier. Let the matter remain in the list.
My learned senior friend is online. But Mr.
My lord,
Good morning, my lord.
Same prayer. Item 142 of the monthly list.
142.
Yes.
142.
Interim order is expiring on 26th. And also, because I'm mentioning upon notice.
142. Serial number 3.
Another item 325 and 326 of the monthly list also with similar orders. So may I hand over the order copy as well as the mentioning notice.
My lord, we are
5
and 326.
my lord, we are applying for the
on 27th August.
applying for the respondent leading by Mr. Nondi, my lord.
Which matter? Which matter?
325, 326.
25, respondent do.
And also, my lord, 128 you lost we just passed. My lord, today morning, Mr. Bhattacharya mentioned, my lord, item number 30.
233, my lord.
That's all, madam.
2. I'm open.
230, I am for the respondent, my lord. This
Which
is the
matter? Which matter?
233, my lord. It's a urgent matter, my lord. You should kindly take it up, my lord, because one storing of
Order number
store matter on the part of my
You are appearing for whom?
of India, my
The
lord.
respondent.
So, my lord, you should kindly
Item
take
number
233 of my lord's list, my lord, the interim order.
today's list.
33. Today's list, huh?
Kindly fix, my lord, short date, my lord,
Same
and fix the time, my
Let
lord.
the matter remain in the
Lordship.
short that if you want to time, then it will go to now October. If you want to let the matter remain in the list, it will remain in the list. The choice is yours. If you want time, if you want the fixed date, then you will go to the after 15th, after the puja vacation. After vacation.
Yeah, let it be. But I just wanted to know, my lord, Lordship has
Yes.
accepted,
What is the submission?
my lord. He is
By
respondent,
submission
he
in
will
the
always
list, my
take
lord.
that.
Yes.
But he is respondent, he will always want to take
Yes.
time.
My lord, item number 30 today morning, Mr. Bhattacharya mentioned. Item number 30 of today's list, my lord.
30.
30.
Ah.
My lord, today morning, Mr. Bhattacharya mentioned, my lord, today your lordship has taken up till 25, my lord. Let it remain the position, my lord, on the Thursday, my lord.
Your lordship, may I have your kind leave to mention item number 634 of your lordship, monthly list, your lordship. The interim order is expiring on 27th, your lordship. I'm mentioning it. Yes, your lordship. I'm mentioning upon notice.
Lordship, may be permitted to mention the matter for extension of interim order. My interim order is expiring tomorrow.
Which one?
Lordship, it is not listed today. My interim order is expiring tomorrow.
Tomorrow.
Tomorrow, Lordship.
It is not listed. Why you not mention how the matter can be uploaded? You could have mentioned in the morning. It comes as a supplementary. एक काम करो उसको ले लो मंडे थर्सडे रख दो टू बी मेंशन
Lordship, grateful, Lordship.
टू बी
My lord.
यस खाली करो खाली
My
करो
lords,
खाली करो
I wish to mention item number 31.
खाली करो
My lords, the state has already started.
That is the problem. If I give some mentioning, then start coming from the queue.
My lord,
all are watching from the outdoor of the court. Once the court started giving the time mentioning, yes, all will come. Yes, court is giving, hearing the mentioning.
My lords, there is an urgency involved in this.
What is the urgency?
My lords, the state has initiated the recovery on risk and cost on my part. That's
yes,
why.
yes.
My lords, the department has initiated the risk and cost recovery on my behalf, on my behest, despite de-scoping my work. So that is the urgency that's
What
why.
is the urgency? You are the private respondent.
My lords, I was the contractor. I was executing a work and against the department. I'm against the department and department has de-scoped my work and they have initiated the risk and cost recovery because they have.
Risk and cost recovery started against you.
Yes, sir.
Cancel the tender or foreclose.
No, my lords, they have
Not
not
foreclose.
terminated the tender. They have not terminated the tender. That is what we are challenging here.
And risk and cost has been.
Yes, they have initiated the risk and cost.
Which item number?
31, your lords.
Okay, we'll see to that. Yes. खाली करो ना, खाली हो गया.
My lord, may I be permitted to mention one matter? This was directed by your lordship to appear tomorrow, but tomorrow there being a holiday, I was just hoping if some precedence could be given. I'll just indicate my learned friend on the other side is enjoying the ad interim order. Although there was a direction for filing of affidavits by them, on the last order, by your lordship's last order, they have till date not used any affidavit. And under the RBI master directions, we have to complete the proceeding by a certain date. So some precedence may be given. My learned friend can indicate how soon can he file.
Reply.
Yes, my lord, may I just make one small request? The affidavit objection is in 6 volumes running into 9,000 pages, my lord. We need at least
Those are all annexures.
2 weeks time because we have to prepare a.
My lord, that is unnecessarily extending the timeline. I'll just indicate, so far as the show cause notice is concerned, when we issued it, upon the concerned bank.
First time इसका पढ़िए देखो. September.
We'll file our reply before that.
May an early date be given before that?
The first I asked.
I'll just indicate why. Because the show cause notice, when was issued by the bank upon the entity, they have never replied. They are enjoying the ad interim order. Pursuant to the order, we have taken down the reporting of fraud from the fraud registry also, which I indicated in another connected matter.
Yes.
Now, under such compelling circumstances, we are supposed to sell the loan portfolio also, which is also hung up because of this proceeding. It has to come to a logical conclusion, and till such time this comes to a logical conclusion, the sale can't be given effect to. So that is, there lies the urgency.
2 weeks if my.
My lord, we'll see. They are just going to come and pay for extension of the
Portfolio cannot be stopped because of fraud.
Yes, under the RBI master directions, it is the
High Court, my lord, in a different proceedings have injuncted.
no, there is a master direction of RBI on which we are governed.
Extension of time to file reply. Let affidavit reply be filed within 2 weeks. List the matter. 2 weeks. आज कितना तारीख है? 2 weeks. List the matter on 15th September.
Grateful to
Within
you.
10 matters.
My lord, the interim order can be extended.
Interim order is extended till the next date of year.
Very grateful to your lordship.
Great.
Yes.
Lord, may I be permitted? Contempt
Again?
application has been filed.
Huh?
For inclusion, a contempt application has been filed.
My lord, may I pray for your lordship's kind leave, my lord, to mention item number 11. My lord, grievance first, my lord, account.
Gradation.
No, your lordship. My lord,
For the bank, your lordship, so we are settling the matter, we are trying to resolve the
Yes,
issue,
my
it will be resolved. If it can be made to be mentioned and
Any
if you
day,
can
your lordship.
trust in,
When?
they
my lord,
will,
any day.
Settled.
it will be settled, your lordship. As per your
Record an
lordship.
order 11.
I appear for the Reserve Bank of India.
Counsel for the parties submit that the talk of settlement between the parties is going on. There is every chance for settlement of the matter. In view of the above, the case adjourned. Let the matter appear on 8th of September 2020.
Your lordship, it will be done day after tomorrow only, your lordship.
Then I am asking you, then you're not telling.
Well,
Let the
any day.
matter appear on 2nd September under the heading to be mentioned.
Grateful, my
Grateful.
May I have my lord's leave with regard to item number 5? My lord, you're all under the impression that it's fixed at 3. But now, my lord, it has become item number 5. There is no possibility, my lord, of that being heard. So, your lordship, my lord, fix a date, my lord, or because, my lord, Mr. Mitro will now start and I'll give a concession which will also work out, my lord. Oh, he's also there. Mr. Mitro Jr. is there.
Any problem?
This, my
Because I
lord,
cannot
kindly,
change the witness action. That's why I speak that.
and there is a fix, I think, matter at 3:45 also.
345, who is there?
Yes, yes, we have a witness section.
That will
And
go on.
record an order.
Kindly, my lord, considering it
Fine.
fixed is, my lord, a short. very
Though
short.
the matter is fixed today at item number
And
5,
time,
but
my lord.
due to paucity of time, matter could not be taken up for hearing. Let the matter appear on 19th, 25th September at 3 p.m.
Well, maybe a little earlier than that.
That is the
I got a slot. She left it on 2nd
That's-
September.
no. 2nd September, there is not.
But she was asking whether people rushing,
Yes.
in temples and courts. This happens when the door opens, everybody rushes.
Yes.
25th at 3 p.m. I'll inform Mr. Mitra.
25th or 29th? What? 25th.
25th at 3.
Great. Yes, call the list.
Lordship, just one request. Lordship, my case tomorrow is fixed for 3:45, but now tomorrow is holiday. Could it be made next week or somewhere?
तो ना इनका जो परसों है ना
Very simple case.
परसों ऊपर में कर. Yes.
Much honor.
Item number 1.
Your Lordship, I am seeking your kind leave to file a special referee report of Devnath Ghosh.
Well, we have received a copy of that.
Remuneration paid.
My lord, the provisional remuneration was fixed by your lordship. That has been paid, but it has to be finalized now. The final remuneration.
So
if
you
your
will go
lordship
through.
directs- I have gone through my lord. I have gone through just now. So,
What do you want?
my lord,
Accept or acceptance or
I'm absolutely. Everybody is accepting this report, my
which
lord.
was the other side?
Lordship, we are for the other side. Lordship, we just received the copy.
Ah.
Let us go through it once,
Ah.
then we'll come back.
Record an order.
And my lord,
The special referee has filed report after serving the copy to land counsel for the parties. Let the same be kept in the record. Land counsel for the defendant prays for time to go through the report. According case is adjourned. Let the matter appear. How soon?
1 week, your lordship.
Let the matter appear on 8th of September 2026 under the heading orders.
10 September.
8th September.
8, my lord, can it be instead of 8? My lord, can it be? No, sir. 6th, my lord. I will be out. I'll be out of town, my lord, from 7 to 11.
September at 10:30.
I'm deeply obliged, my lord.
6 September at 10:30.
6 September, I was like Saturday.
No, the smile is quite acquainted. No, I'm acquainted to that smile.
My lord, it is Sunday. 6th is Sunday. 7th, I'm going out.
No, then can it be Miller on the 3rd? Can it be on the 3rd?
My lord. And my lord,
Ready, madam? 3rd.
And the additional remuneration for Mr.
Yes,
Come on that day, I will see.
Kindly.
After acceptance, I will release also. If yes, next. ये साइन हो गया अच्छे पक्का तो नहीं हुआ This court has held that the writ petition is maintainable and the impugn order is still till 24 September. The defendants are respondents are directed to file affidavit in opposition within 2 weeks. Reply within 2 weeks, 24 September.
The interim order,
That's why till 24 September.
Can it be extended by a week instead of 2 weeks, 3 weeks? Why not? Because
I have given short date because you
no,
will
they are
say-
in Chandigarh. That is it.
because I have given short date because it's 3 weeks.
3 weeks instead of 2 weeks, 3 weeks. Then they will come. I will send it to Chandigarh. They will get. I don't know.
3 weeks. Reply if I need that to file then instead of 24 September. 6th October. Till 6th October. Thank you. Next.
Your name, sir?
Ramesh Kumar Kejriwal. Ramesh Kumar Kejriwal.
Further cross, huh?
May I proceed, my lord? Shown answer to question number 215. Are you in a position to answer the question today?
You continue.
215. Yes.
It will continue.
Yes.
345 में कौन है?
He asked me that, do you have, asked my juniors, do you have another witness? So I said, yes. And I gave him the name.
The testator.
He said, he'll be the best witness.
You make a subpoena, then planchette.
Then he will go.
But who will see?
He will go. Who will go to deliver subpoena, my lord, he will go.
First subpoena has to go.
Yes, yes. He will go.
অন্ধকার করে ঘর।
Yes. बच्चा डेथ वाला वो तो फिर करेगा ना।
Sir, I did not see this record.
Question number 15 to 215 was asked. Okay, you had answered
Check करके
something
बताएंगे।
that you say.
अच्छा सर हम वो चेक नहीं कर पाए।
Loudly.
Sir, I could not check this. Next date में हम बता देंगे सर।
I could not check this answer. Next date I will answer to the said question.
Do you recall that a suit was filed before the court at Alipur with regard to partition of the residential house at Bali 57G Baligan Circular Road?
Yes, sir.
I am showing you a document. Please look at this and say whether this is the plaint filed in that suit.
Yes, sir.
My lord, on admission, let this document be marked exhibit. Only thing, there are many flags on that document. May I give a photocopy of the document, my lord? এটাও একটু সাথে দেখি 2778
Where is the summon?
Yes, that's
Summon
the
you're
original
not
that we
Xerox.
had, but it's marked. So
Summon you're not Xerox. Otherwise, this could have been taken as.
we will do it right now, my lord.
Copy of plaint of title suit number 2778 of 2010 within bracket Dr. Vijay Kumar Kejriwal versus Murari Mohan Kejriwal and others filed before the Learned Court of Civil Justice Second Court at Alipur is marked as exhibit 21 without
along
on
with
admission.
My lord, along with the writ of summons, my lord.
On admission, along with the writ of summons. It is not a writ of summons, along with the summons.
Along with the, I'm sorry, along with the summons, my lord.
That I faced difficulty initially when I hold the determination of the original site.
But we are not objecting summons because these are
Reciprocating. Along with the summons. Reciprocating. You give the copy to that.
Yes.
Yeah. Photocopy of the first page. उसका copy करके दे देगा तो उसको जरा उसका exhibit करो. Yes, next.
Did you file a written statement in this suit?
ऐसे देख के बोलना है कि हाँ बोलना है?
नहीं आपको याद है
सोच के
आपने
बोलिए,
इसका
आपको
रिटर्न
याद है
स्टेटमेंट फाइल किया है?
Do you remember or not?
हाँ सर किया है सर.
Yes, I have filed a written statement.
I am showing you a document. Please say whether this is the document by which you had adopted the case of the plaintiff in that suit.
Yes.
Allowed on admission, this document be also be marked as an exhibit.
Marked as exhibit 22.
Exhibit 22.
हाँ.
Yes, next.
Prior to institution of this partition suit, do you recall that you and Dr. Vijay Kumar Kejriwal had filed a suit before the learned civil judge junior division at Alipur against Mahesh Kumar Kejriwal and Murari Mohan Kejriwal? Sometimes in August 2007.
सर वो कागज देखना पड़ेगा क्या ऐसे ध्यान नहीं सर.
I need to look at the document, then I can answer it. Document, then I can answer.
I am showing you a document. Please look at this document and say whether this is the plaint in respect of title suit number 915 of 2007, which you and Dr. Vijay Kumar Kejriwal had instituted before the court at Alipur.
Yes.
Yes,
May it be marked as an exhibit on admission, my lord.
23.
On admission.
I suggest it to you that despite having financial means, you failed and neglected to make any contribution to the costs for medical treatment and costs for the last rites of your mother, late Savitri Devi Kejriwal. Full stop. What do you say?
आपके पास पैसा रहने के बावजूद आपकी जो माता जी हैं उनका जो इलाज का खर्चा है उनको नहीं उठा पाए. आप ये मानने को राजी हैं? I do not agree.
I do not agree.
I do not agree.
I suggest it to you
लेकिन सम्मन का कॉपी लगेगा.
that just a few days after the death of your mother, late Savitri Devi Kejriwal, you purchased a Chevrolet car worth about rupees 20. Chevrolet car,
Chevrolet car.
Chevrolet. Chevrolet car worth about rupees 24 lakh. Full stop. What do you say?
Do you agree?
I do not agree.
I do not agree. I do not agree.
I suggest it to you that despite having the financial means, you failed and neglected to make any contribution to the costs for the medical treatment and costs for the last rites of your father, late Murari Mohan Kejriwal. Full stop. What do you say?
आपके पास आर्थिक सामर्थ्य रहने के बावजूद जो खर्चे थे, आपके पिताजी के जो लास्ट राइट के खर्चे थे और माताजी का जो इलाज का खर्चा था, वो
पिताजी का मेडिकल
ट्रीटमेंट और
पिताजी का लास्ट
राइट, इसका खर्चा आप नहीं उठा पाए.
It is a fact. उस समय हमारे पास में पैसा था.
It is a fact that at that point of time, I had money.
I offered Mahesh कि पैसा लो.
I offered Mahesh some money.
He told me.
नहीं, I offered Mahesh to take some money from me,
But he
refused to take any help from me.
But he declined to take any help from me.
I suggest it to you that there is no evidence on record to suggest that you had offered any money to Mahesh Kumar Kejriwal for the medical treatment or for the last rites of your father, late Murari Mohan Kejriwal. Full stop. What do you say?
On record, कोई एविडेंस नहीं है कि आपने आपके भाई को पैसा ऑफर किया था. आप ये मानने को राजी हैं?
नहीं सर, हम चिट्ठी तो नहीं लिख के दिया था, पर मुंह से बोला था उनको.
I did not write any letter to my brother offering money, but I had offered the money verbally to him.
I suggest it to you that you had attempted to usurp the properties and assets of late Murari Mohan Kejriwal even during his lifetime. Full stop. What do you say?
आपके जो पिताजी थे वो जब जीवित थे तब आप उनका प्रॉपर्टी हड़पना चाहते थे.
नहीं.
वो जब जीवित थे.
Not a fact.
No.
I do not agree.
I suggest it to you that there are many cases and counter cases filed by you and late Murari Mohan Kejriwal against each other. Full stop. What do you say?
आप और आपके पिताजी के बीच केस और
litigation cases,
litigation
and counter litigation.
ये वो
cases and counter cases ना बोले, litigation and counter litigation.
उनके ऊपर कोई केस किया नहीं था, पिताजी के ऊपर.
I had not filed any case against my father.
महेश केस करता था.
Mahesh had filed some cases, several cases against
उसी को डिफेंड करते थे.
my father and
No. Mahesh
against
used
me.
to file several cases against me, and I used to defend
those
said cases. Mahesh used to file several cases against me, and I used to defend all the cases.
I suggest to you that you had lodged criminal complaints against your father, late Murari Mohan Kejriwal. Full stop. What do you say?
आपने आपके पिताजी के अगेंस्ट में क्रिमिनल कंप्लेंट लॉन्च किया था. आपको क्या कहना है?
हमने कोई किया था और कोई केस देखने से कुछ समझ में आया था बात है, हमने कुछ नहीं किया सर.
I do not remember lodging any such complaint against my father, but if I look at the documents, then I can answer it.
Look at के नहीं किया सर.
ठीक, थोड़ा किधर दो.
I suggested to you that the relationship between you and late Murari Mohan Kejriwal had become acrimonious since 2006. Full stop. What do you say? Since 2006.
2006
What
से
do you say?
आपके और आपके पिताजी के बीच जो संपर्क था वो बहुत ही तीखा हो गया था, खराब हो गया था।
नहीं सर, हमारा संबंध तो बहुत अच्छा था उनसे।
My relationship with my father was very good.
हम लोग 2007 तक साथ में थे।
We were together till the year 2000. We were
living
together till the year 2007.
तब तक बहुत अच्छा रिलेशन था सर।
Till that time we had a very good relationship with each other.
उसके बाद में हम लोग घर छोड़ दिए थे सर।
After that I left
the
house.
उसके बाद में उनसे बहुत संपर्क महेश रखने नहीं दिया।
And thereafter Mahesh did not let him keep any relationship between me and my father. Allow.
Mahesh did not allow me to keep any relationship with my father. मनुतोष उसको बोलो एविडेंस के समय ना ऑनलाइन नहीं चले
एक बार आंसरটা একবার পড়ে দেবেন।
36, my lord. Just for short, he's on his way.
Short passover is fine. my lord.
He was on
My lord,
court number
because this
36. He's
matter,
coming.
my lord, is protracted, my lord, and it's causing trauma to my client, my lord.
Well, it is
If I
to be
may,
concluded too.
remind my lord, this is the IVF matter which resulted in, my lord, my daughter's death.
Yes, I
So,
remember.
my lord, if
He will
you can
conclude
do
it today,
her,
my
you
lord.
take, my
What
lord.
is
I'll under short
Yes.
passover.
But the advocates come. I don't know. I have to take
My
the
lord.
matter.
My lord, Mr. Kaur is on the way soon.
Okay, short passover.
Item number 6.
Lordship, item number 6 for the. May I start? Yeah. Lordship, this is my writ petition based on a tender, Lordship. Based on a tender. This was there is an order which says that no effect of to the tender has to be given until the writ petition is decided. We have come after affidavits, Lordship. The private respondent and the state has filed the affidavit. Lord.
Affidavit filed?
Yes, Lordship.
Yes. So tender with
Lordship, yes, Lordship. So
the work order is given.
Yes, Lordship.
Work order is given.
Yes, Lordship. It has.
You are challenging the work order.
No, Lordship. I am challenging the application itself. The challenge was during pendency of this writ petition, and while there was an order, they have allotted this to the private party, that is respondent number 5. But they have mentioned in that letter that it will be given effect to after. May I hand up the order, Lordship? The allotment order, Lordship. I have given that order.
Yes. Yes.
Now, my lord, I am for the petition. We are, my lord, in nutshell, tender issued, floated for a plot. I am one of the participant.
For lease.
For lease. I am one of the participant. The framework was that within 2 o'clock of a particular date, the bid has to be submitted physically. So my representative went there, submitted the bid within the time. He was waiting there, and he has experienced that the private respondent who is there in this matter, his representative submitted bid post 2 p.m. Specific complaint raised on that very date. All along, the stand taken by the authority is that no, there was no wrongdoing. It was done within the framework. Thereafter, we on our own found a document which is the entry register in that building, which records that the representative of the private respondent entered the premises at 2. He could not have submitted bid at 2. To that, the defense taken is we were in hurry, so we couldn't sign anything properly. It was made in, and the that is the sole defense taken. I'll take your lordship through these papers now. Kindly come to.
So this is, now it is to be started. If I finally.
Pleadings complete, final hearing.
So
now there was a prior round of litigation.
So I am fixing a date.
There was a date fixed already. Every time either because of our resolutions, we also can't come and do the matter. That's the problem. That's why I request Lordship to cancel the fixing and we can do this anyway. Today when I'm the lucky, is a lucky day. I have had the opportunity to.
Because I have passed your matter, Mr. Carr is there. Pass your matter.
He sir, कुछ नहीं होता. Carr is also there. For the private respondent, he was appealing. He is also there in that matter. He was there.
So relaxed. Never realized that my matter was going. My fault. Yes, sir.
For private respondent, my land senior is appearing for the private respondent.
Yes.
Actually, there's a matter which has been passed.
I can come back to next. Kindly, people, but only prioritize the matter because Lordship has Thursday that I can.
Learned counsel for the petition argued the matter at length, but due to paucity of time, hearing could not be completed. Let the matter remain in the list.
But if it can be not at the top of the.
It will remain in the list.
Actually,
as it is, it will be there.
Very good.
Yes, next. Pasua.
I'm really sorry, my lord.
Yes, no
I was not there in time. You can use my briefs. I'll get into the wrong points.
For the state.
My learned friend was kind enough to offer his brief, but I said that I can't look into it because I get into the wrong points.
Then it will be difficult to quote.
Where's the brief? Now, my lord, may I just summarize, my lord, the submissions on behalf of the petitioner. My lord, the basic contention is that, Lord, certain guidelines were violated. These guidelines are non-statutory guidelines which have been violated. This is one. The other aspect of the matter is that there was a mix-up in formulating the embryo, because they are saying that firstly, embryo of a third party, the wife and the male and female of third parties were consisted of the embryo, not of self. That they had not consented to. This is the basic point. And the lastly, on which the regulatory authority has given a lot of credence is the fact that two experts' opinion were taken that there was impropriety in the procedure. So, if I may just say 4 points. First is consent of the husband was not taken. Second is identity of the third party not revealed, because when the situation came, the father, the biological father, could not be traced. Third is forgery of signature. And 4 is violation of the guidelines. These are the 4 points on which, the argument has been advanced. Now, firstly, there were several proceedings, which have been initiated. First is the criminal case. If your lordship's is kind enough to take page 444. This will be in volume 3.
Yes.
444.
Yes.
This is a police complaint.
Yes.
Lodged to Korea Police. Kindly, come to the second paragraph.
Yes.
Kindly, see 1, 2, 3, 4th line. Sentence starting with the word recently.
Yes.
Has your lordship found that?
Yes.
Recently, after much efforts, we were provided of the alleged documents, including copies of the alleged documents, including agreements and consent from which we had allegedly executed. I was shocked and surprised to find that the supposed agreement for IVF, etc., dated 12 March 2018, copy of which has been provided to me, has my signature forged on it. So, 12th March 2018, one document, she is alleging that there was a forgery. As mentioned above, the treatment I and my husband opted for was for octic to be collected from me and sperm to be collected from my husband. As such, in the
first page of the
agreement, we have ticked on the options, my occates and sperm of my husband, etc. This is not important. Is the forgery is the charge. Now, my lord, if your lordships kind enough to take page 12th March 2018 is the consent form, which is at page 434.
Yes.
Clause 2.
Yes.
We consent to the mixing of the following. It's against my occates to sperm of my husband, anonymous donor, anonymous donor. Now, your lordship turns the page, comes to page 436. Your lordships will find the signature of the wife is there. This is what she is alleging is forged.
Yes.
Gunjan Kothari, this is the signature she is alleging to be forged.
Yes.
Now, my lord, while at this page, if my lord kindly also looks at page 424, 424.
Yes.
Now, this form was the second attempt. This is, my lord, dated 12th June 2017.
Yes.
And your lordships will find anonymous donor and anonymous donor is struck out.
Yes.
If your lordship looks at
Husband and my octaves.
yes, and her signature is at page 426.
Yes.
Now, my lord, as a routine procedure was carried out thrice, lord, husband signed each time at the final stage. The first two procedures are, lord, not under challenge, but I just showed it to your lordship to show that, lord, in the second one and the first one, this second option was struck out. The first one your lordships will get at page 412.
Yes. So 412 is the first one.
First one, self procedure.
426 is the second one.
424 is the second one.
424 second one. And 436?
436 is the third one.
Third one.
Now, Lord, in the procedure, there are various stages. So this is, Lord, form at 436.
Yes.
Is at the initial stage.
Yes.
The first stage where, Lord, consent is obtained.
Yes.
Then, Lord, if your lordships, Lord, kindly come to page 438. This is at the stage of taking off collecting the sperm and collecting of the eggs. This is also signed by Gunjan Kothari. Your lordships will find the signature at page 438. There is no, Lord, allegation of forgery so far as the second signature is concerned.
Yes.
It is the first form where she has agreed to go for third party, Lord, procedure. This has not been, Lord, the allegation in the FIR is nothing to do with the 438, page 438. Now, Lord, after this, there are some medical procedure which was carried out on 22nd May 2018, which your lordships will find at page 105, first volume. First volume, your lordships will find at page 105.
Yes.
Kindly come to the bottom of the page, your lordships will find the clinical procedure which was carried out. 105 bottom. This was done on the 23rd of May. 22nd of May.
22nd May 2018.
And 23rd, Lord, actual transplant took place. If your lordships, Lord, kindly come back to page 443.
Yes.
Now, your lordships will find that on this page, there is a signature of both husband and wife. There is no Lord allegation that these signatures are also Lord forged. The forgery is only with regard to the first date, 12th March 2018. Now, your lordships may kindly have a look at it at page 443.
Yes.
Number of embryos transferred to in the 1, 2, 3, 4, fifth column. To number of embryos left at IHR 2.
Yes.
Now, your lordships will kindly come to page 439. This is, Lord, the consent for cryopreservation.
Yes.
Your lordships will find extra embryos.
Consent form by wife.
Yes. Signed by wife. Extra embryos. This is, Lord, number of embryos 4.
Yes.
So, Lord, out of 4, 2 was implanted, which your lordships have seen in 443.
Transferred to
2 and 2 was kept in
IHR.
with this IHR. Because, Lord, what happens is many times the procedure fails. When the procedure fails, instead of again, Lord, going in for this procedure, this is extra is preserved.
Correct.
So that, Lord, again this transplant can take place. Now, Lord, what has happened here is that, Lord, the child fell sick. Lord, she had cancer, blood cancer. Now, because she had blood cancer, first, Lord, the parents, Lord, there is a DNA, Lord, procedure for treatment. The parents' DNA was tested, it didn't work. So, Lord, they approached the institute. The institute, Lord, contacted the mother, and the mother went and gave her DNA, biological mother. Normally, Lord, these names are kept secret. They are not to be disclosed. But, Lord, mother went and gave their DNA. The child didn't, Lord, improve with this DNA test. So, Lord, they wanted biological father. Unfortunately, the biological father had changed his address. And the address that the institute had, that address, we couldn't trace the father. So, Lord, this is, in short, the matter is all about. The question is that, Lord, whether the guidelines have been
followed or not?
Followed on, and whether these guidelines are statutory guidelines, and, Lord, what is the effect if it is not followed, whether enforcement of these guidelines can be had. Those are, Lord, legal issues. But first, Lord, let us see whether, Lord, the guidelines have been at all, Lord, violated. Lord, if your lordships, Lord, kindly see the guideline, which is at page, guideline to 501, page 501. That is volume 4.
Yes.
please come to, it starts at page 501.
Yes.
If your lordships, my lord, kindly come to page 574 or 573, there is a heading, clinics which should be registered.
Yes.
Now, my lord, 3.2.5, consent. No treatment should be given without the written consent of the couple to all the possible stages of that treatment, including the possible freezing of supernumerary embryos. A standard consent form recommended by the accreditation authority should be used by all ART clinics. Specific consent must be obtained from couples who have their gametes or embryo frozen in regard to what should be done with them if she dies or becomes incapable of varying or revoking his or her consent. Now, just Lord, to pause here for a moment. Lord, at the final stage, the husband had signed the form. Although he did not sign the first two stages, but Lord, at the final stage, he had signed the form.
Yes.
So, Lord, there may have been some irregularity, but Lord, when at the final stage, when the embryos are planted, Lord, at that stage, the husband had given his consent. There's no reason, again saying that he has not, or he was not aware of the procedure. So this is one aspect of the matter. 3.2.5, definitely it says that written consent to be taken at all possible stages of the treatment. All possible stages of the treatment.
That means 1, 2, 3.
1, 2, 3. And here, Lord, on 1, 2, the wife has signed. 3, the husband has signed.
So 1 and 2, there is no signature of the
husband.
Whether that can be taken as negligence or the irregular.
Number 1. Number 2, Lord, when the husband signs the final one, can it be
deemed that the consent?
Can it be taken as a deemed consent? So far as the first and second stage is concerned. Lord, one fact which should be kept in mind, and this is not taken by us in the affidavit. Sometimes later, Lord, once I formulate the point, I will show your lordship the affidavit. This lady was related to Dr. Emil, what is his name? Goenka, Emil Goenka, who was Lord a pioneer in this field. And she came to him. Basically, she came to him. He was his doctor. He is no longer alive. He was attached to this institute. Now, Lord, whatever happened between him and the patient, it was always a matter of secret, because it was a family issue. He never wanted to divulge. He had the patient under him. So basically, whatever was done by him, but all records are maintained. And I will, when I come to that point, I'll show to your lordship that, Lord, the proceedings that was initiated, there are as many as 5 proceedings which have been initiated. One is that FIR. Second is, Lord, a complaint to the principal secretary under the act, this ART Act. Third is, Lord, NCDRC. They had claimed about 68 crores as compensation. And fourth is the clinical establishment against which this writ petition has been filed. And also they have directly filed a complaint to the ART authorities sometimes in 2024 after, Lord, the act came into force. Now, these are the 5, Lord, different complaints. The health department was previously, Lord, the authority looking after these clinics. So Principal Secretary Health was addressed. Now, Lord, out of this, NCDRC has rejected their claim, because NCDRC has held that, Lord, the issue is in regard to forgery of a form. So that goes to the root of the matter, because if she has not given consent, then, Lord, subsequent procedure which was followed
automatically
will automatically follow. So therefore, NCDRC says that it will depend on the outcome of the criminal case. And as an SLP was filed, the special leave petition has been dismissed. Lord, we get from the Supreme Court website that the SLP was dismissed, Lord, on 23rd of August 2026. But Lord, the order has not been uploaded, but the status shows that dismissed, leave granted and dismissed. So Lord, there must have been some judgment with regard to that. This is the order of the NCDRC. Oh, extra copy chole geche. There, I think, sorry. Paragraph 7 and 8, Lord, if your lordships kindly take. Paragraph 7 and 8. Yes. After due consideration of the submissions made and carefully peruse the records, we are of the considered view that the matter contains the allegation of procedural violations in intricate IVF procedures, serious allegations made by the complainants against the OPs with respect to forgery, fraud and cheating, including the consent form, while the learned counsel for the complainants vehemently argued that the actions of the OPs as brought out in the complaint have significant implications of gross deficiency in service and unfair trade practices, and that these grievances of the complainants are liable to be proceeded against independently against the OPs, notwithstanding the other complaints. Therefore, we are of the considered view that the matter entails evolution of intricate and complex IVF procedures and other associated medical as well as DNA evaluation process. Further, the complainants made serious allegation of forgery, fraud and cheating against the OPs, which in our considered view could be more appropriately tried before a civil court than in a summary procedure before the commission. The Honorable Supreme Court in so and so has crystallized the absence of scope of consumer fora to adjudicate the matters entailing allegations of forgery by observing, these are the observation, and then the case is disposed of. Yes. Basically, Lord, it is raised above the mere deficiency of service. So, Lord, when there is forgery, there are criminal aspect involved in a matter. It's not a simple deficiency of service. It's deceiving, cheating, all these things come into play. So, Lord, the forum says that this can't be done in a summary procedure. Yes. This has to be done by a civil court rather than a summary procedure for the commission. Now, Lord, the Supreme Court, we haven't got the order as yet, but the status report, this is the status report from the website. Kindly see, Lord, in the middle, it says status disposed. Yes. Now, Lord, coming back to the guidelines. After 3.2.5, please take 3.2.7. Yes. Use of gametes and embryos, no more than 3 so and so may be placed in a woman in any cycle regardless of the procedure. Kindly see the next sentence. No woman should be treated with gametes or with embryos derived from gametes of more than one man or woman during any treatment cycle. Now, Lord, this is one of the allegations that there was a mixture of the self with third party. Now, Lord, if not in the knowledge of the petition, which was not in the knowledge of the petition. Now, Lord, if that was so, then, Lord, the father and mother's DNA would have matched. Their DNA, if there was firstly, Lord, such a procedure cannot be carried out by no clinic. No clinic will carry out such a procedure. Number one, there may be genetic problems in that. No clinic will take that risk. Secondly, if for the sake of argument we accept that this was mixed, then Lord, when the DNA was required of the mother and father, their DNA would have matched.
Correct.
Not the biological mother alone. And the biological father, of course, could not be. So, my lord, this nullifies the contention that, Lord, there was a mixture. In any event, the guideline says that there shouldn't be a mixture. And it is the
Yes.
it is the consistent stand of my client that there was no mixture. If there was a mixture, if for the sake of argument we say that a gross negligent act was done, then the father and mother's DNA, I mean not natural, the other foster parents, their DNA would have matched.
Correct.
That did not. When that did not, which for that reason we had to call the biological.
The biological father is still
No, still not available. But the address that we have, there, Lord, he is not residing. And I have stated that in the affidavit. I'll show it to your lordship. That, Lord, in the affidavit we have taken this stand that it is the biological Lord, if we go to such an extent of helping them with the biological mother be made available, why shouldn't we, Lord, unnecessarily help them? We will definitely help them. If we
with regard to the DNA mother, it is
matched. Biological mother match, but it didn't work. Maybe, Lord,
didn't work because the father is not there.
Father or whatever reason, Lord, it didn't help the child. I can only say this, that it didn't help the child. It matched, definitely matched. Those reports are also on record. Now, Lord, your lordships may kindly, after that, come to 3.4.8 first. This is, Lord, right of the child, 3.4.8. That the child has a right to know about his genetic parent, surrogate mother, on reaching the age of 18 years.
Yes.
And it is also an obligation on the couple not to hide this information from the child. Now, my lord, your lordships may kindly come to 3.5.1. This is an undertaking to be given by the to the third party that the offspring will not know about his or her identity. She must also be informed of the provisions of section 3.4.8. Now, my lord, your lordships kindly come to 3.5.6. No ART procedure shall be done.
No one has challenged the 3.4.8.
I don't think so. I don't think so.
Yes.
This is, Lord, I can only be frank that hardly any child who's brought up, Lord, are informed or told. I mean,
that's what I'm telling you. No, because if the matter comes,
but transparency sometimes bring in pain. So, Lord, maybe, Lord, at times silence is better than
to disclose.
Maybe, Lord, someday your lordship is right. This issue might come up within the rights under Article 19, Article 21. Someday, Lord, Supreme Court.
See, if tomorrow, okay, majority attain the majority, and in the mind of the child, yes, I
want to know.
You want to know. So what would be effect? Leave aside the parents who developed. What about the mental condition of the child who will go for the search of the biological father?
In fact, Lord, I faced a very, very peculiar situation. I just take 2 minutes to. Lord, a mother with a daughter tried to commit suicide in Allahabad. The last moment, the child, whose daughter was a child, I think she was just 2 years old or so, she moved out of the track. As a result, her legs got cut. And the mother was dead. Police, they searched but couldn't find the other connected family members. So, the child was put in a home. Now, my wife used to know some homes here in Calcutta because she was doing some NGO work at that time. So, a lady who's a social worker there contacted her that if this home in Calcutta, this Mother Teresa's home were there, and there were a couple of more homes. Those days, this CARA and other guidelines were not there. So she was put in one of the homes here, and she was adopted by a Swedish couple, and she went to Sweden. In between, she had those prosthetic legs made, and artificial legs, and she was able to walk. Now, surprise of surprises came about 2-3 years back. My wife was contacted by the same girl. Now she is grown up. She is a teenager, and she wanted to find her family. So she wanted to go to Allahabad and wanted my wife to accompany her and to go and see if some trace can be found out. But unfortunately, nothing could be done because at that stage the police did not and she may have come out from some other place or whatever. But this happens sometimes. The children, when they grow up and they are told about this, especially if they are taken to foreign land, foreigner parents, foster parents, they try and disclose to the extent possible. Yes. Now, 3.5.13. Yes. Use of sperm donated by a relative or a known friend of either of the wife or the husband shall not be permitted. It will be the responsibility of the ART clinic to obtain sperm from the appropriate banks. Neither the clinic nor the couple shall have the right to know the donor identity and address, but both the clinic and the couple, however, shall have the right to have the fullest possible information from the semen bank on the donor, such as height, weight, skin color, educational qualification, professional, family background, freedom from any known disease or carrier status as hepatitis B or AIDS, ethnic origin, and DNA fingerprints, if possible, before accepting the donor's semen. It will be the responsibility of the semen bank and the clinic to ensure that the couple does not come to know the identity of the donor. The ART clinic will be authorized to appropriately charge the couple for the semen provided and the tests done on the donor semen. So, this is again a secrecy clause which the ART clinic is supposed to maintain under the guidelines. Correct. Now, if your lordships come to 3.5.15, when the DNA fingerprinting technology becomes commercially available, the ART clinic may offer to the couple a DNA fingerprint of the donor without revealing his/her identity against appropriate payment towards the cost of DNA fingerprint. An ART clinic will then have DNA fingerprints done of the couple and keep the DNA fingerprints on its records. Then, kindly come to 3.5.18. Semens from two individuals must never be mixed before use under any circumstances. Then, 3.5.22. The consent of the consent form must be a true informed consent witnessed by a person who is in no way associated with the clinic. Now, let's also take 3.12.2. 12.2. Yes. Children born through the use of donor gametes and their adopted parents shall have a right to available medical or genetic information about the genetic parents that may be relevant to the child's health. So, my lord, this obligation was performed to the extent of the mother, the biological mother. The address of the father
Not available.
was available,
But
he was not available at the address. This is where the situation is. Now,
yes,
if I may just take your lordship to the impugned order.
We'll continue. 435.
Oh, sorry, my lord. But I tell your lordship, I just take another half an hour maximum. I cite a few judgments. The main contention is that, Lord, whether consent was given or not, that is an issue that can only be decided in the criminal case. At least prima facie, I have shown that in all the forms, first, second, third, the mother has signed. And as a matter of regular practice, the father has signed only, my lord, the final stage forms. Only the final stage forms. Now, my lord, whether that should be a deemed consent or not, that is one aspect of the matter that I will argue. And the other is that, Lord, the tribunal proceeds on the basis of violation of these guidelines and says that 5 lakhs of rupees you pay as fine, because this is held to be irregular. There is nothing illegal.
So that's right, because there is two questions. Two forms not signed, third form signed, which is a final consent.
Yes.
So it deemed consent. If it is not a deemed consent, it was not brought to the notice. So whether that is a criminal negligence or irregularity.
Absolutely.
These are the
Absolutely. The
with regard to
tribunal
this form.
Absolutely.
Form aspect.
Form. And Lord, tribunal has held that this is, Lord, an irregularity and has put a fine of 5 lakhs.
Or it is if it is a mandatory or what?
Mandatory. That is one aspect I'll argue. The other is, Lord, under the Clinical Establishment Act, whether there is any provision for, apart from fine, awarding anything apart from fine. This is the other aspect I will have to highlight.
Learned counsel for the respondent number.
Five.
Has argued the matter at length, but due to paucity of time, hearing could not be completed. Case adjourned. Let the matter appear. Before vacation or after vacation?
No, before vacation.
Very well.
6th October. Right?
6th October. I can only say that your lordships will have so much of pressure of motions at that time. Keep it after the vacation. I think keep it after the vacation.
Kindly.
The problem is that you'll have just 1 week after that. So if your lordships are kind enough to keep it after vacation, otherwise I'll argue, my lord, on the 6th. I have no objection.
I am giving after puja vacation 2 dates. Continue.
Yes.
Let they come.
Yes.
May I renew my prayer for it to be marked part on, my lord? Now,
yes.
Kindly, since it
both parties what? Both parties.
Due to the pattern, I am dealing in the group 9 as a total original.
Kindly, my lord, your lordship has heard it substantially. I'll just take 1 day's time so far as I am concerned. One hour for me, and then, Lord, my learned.
13. 12 and reopening day?
Yes. Reopening?
12th, it is a reopening. Okay, then 16 and 17 November at 3 p.m.
Yes.
My lord is marked it part. My lord, again, my lord, my clients will have to go through this. My lord, I'm grateful.
Well, item number 205, today's list SIR matter, it is dismissed for default due to my mother. My 205 item number, appellate side matter, SIR matter.
There is no staff.
My lord, due to my mother's illness, I could not come in time, my lord.
Let us in.
My lord, 205, my lord, item.
Let me see this.